When did you file? Just a minute. Switch on the microphone.
I want most of it.
For Tuesday. Tuesday.
Most of it.
May I please, Your Lordship, I beg to mention item number 6 of today's daily list.
Yes.
Your Lordship, the engaged counsel is out of station. He is at home. He's on his way, but due to delay of trains, he's stuck.
Okay. Later matter reach. We'll consider. Later matter reach.
Okay. Obliged, Your Honor. Yes. Item 6. Item 6.
In case Lordship earlier occasion asked to provide instruction regarding whether petitioner was appearing or not before the concerned SP Lordship. That instruction, Lordship, I will provide Lordship for the time being pass over the matter. For the time being, Lordship, pass over the matter.
Inform us after some time.
After some time, Lordship, within half an hour, Lordship, I will provide.
May I please, Your Lordship? Well, LC has come, my lord, just now.
Let
Lordship,
us-
can you-
Take your seat, Mr.
Mine.
বা ইনকুৱাৰী প্ৰচিডিং হোৱা নাই, জাজমেণ্ট দিয়া আছে। তুমি এটাৰ অৰ্ডাৰ কপি দেউতাক পৰিকল্পনা দেউতাকৰ মতিলাল পাল হৰিপদ আহমেদ কোৰ্টত
Hmm?
You note down the page number. Page number 22, 23. Then 27. Then 28.
Offense to heavy against the Bhutapur. Against the কিন্তু এখন পরিবর্তন করা যাচ্ছে কিন্তু দেখা নিতে
Control. Now see, see the notice also. No, it is there. Report police. After police report, you will not get in the part. You get it later. Hereafter. After that inquiry. It's issued to whom?
Only Hariput Karmakar.
First of all, the enquiry was against the Holy Potter. There is no enquiry against his
Meera
wife or
Karmakar.
his children. But that yellow mark page, you will see the Superintendent of Police ordered while referring the matter Haribodha
His family
Karmakar and
member.
his family. In fact, the tribunal
Yes.
accepting the report of the Haribodha Karmakar should have referred the matter back to the referral authority
Yes, sir.
because there is no such inquiry against his
And
wife
Miracle.
or his children.
Yes.
So, but continue. Notice was issued to Haribodha. And what to do?
Report promoter case for crime register করেছিল।
The record is before you.
Yes, doctor. Ultimate.
To take out the petition as this order will be passed.
Yes, doctor.
It was the duty of the tribunal
Hmm.
to accept the report with Haribodha Karmakar and to proceed. Probably for that reason, he had issued the notice.
Hmm.
Because the member of the tribunal changed.
Yes, doctor.
So if you see the order sheet first page. Order sheet first page. Order sheet first page. First page. Order sheet. This is the front, there. First order. It is.
Yes, doctor. There is nothing against the other pending.
Exactly. Mr. Pine?
Yes.
Set aside this order. Yes. But there is another matter pending. You will get an order just with regard to Haribodha Sarkar, there is a direction. You will see in this report. There is an order passed by Brother Justice Gujar Burua and others. It's available. WPC 228 or something like that.
Yes, yes. 884 of 2018. 884 of 2018.
Two 2018.
Yes, doctor. 884 of 2018. It was on 23/6/2023.
Probably that matter is now pending before the tribunal.
Maybe, lordship. Full record was found genuine, lordship.
Okay. Give us the record. The Muslim Mandal, the Honorable Full Court, full bench have clarified if the tribunal is not satisfied, you can send back the matter to the referral authority. is there. Because before.
Hmm.
Yes. Heard Mr. J. Daman,
Very good.
counsel for the petitioner, Petitioner. and Mr. Z. Sharma, understanding counsel. Before that, you like.
Yes, ma'am.
UK Goswami and HSDC for the rest of number. Also heard Mr. Z. Sharma, standing counsel from Department of Some for the rest of number. Mr. A.I. standing counsel. Election Commission. Is G. Sharma 2 and 6. And Mr. P. Sharma, additional senior government at Assam for the rest of number 5. The petitioner's hearing being dissatisfied with the impugned order dated 30/08/2017 passed by Planet Furnace Tribunal 5th, Morigaon, Assam in case number F.T.129/2016. Declaring the petitioners to be foreigners under the Foreigners Act 1946, who had illegally entered into territory of India within Assam on or after 25/03/1971. Filed the writ petition. Being amongst others to set aside in court the impugned of said impugned opinion dated such and such. Petitioners contended that petition number 1 is the wife of on Haripada Karmakar, whereas petitioner numbers 2 and 3 are the son and daughter of the petitioner number 1 and said Haripada Karmakar. Sir, how much take your seat? Petitioners contended that there was no proper inquiry against them with regard to them pertaining to their nationality. And the concerned referral authority, ID Superintendency of Police Border Morigaon, wrongly referred their case to the Foreigners Tribunal for determination of their nationality. It is also submitted by the petitioner that though they have submitted relevant documents, the tribunal, without considering them in proper perspective, but the impugn order dated 30/08/2017 declared them to be foreigners under the Foreign Affairs Act. আগতে by impunity, by common law. Declared a petition of the or husband of people. Earlier, notice in this case was issued on 27/08/2018. In the record of say case number F.T.129 of 2016 was called for from the Foreigners Tribunal to Maigaon. Further, by order dated 27/08/2018, in the interim, the court directed not to arrest the petitioners, not to deport them from territory, which is still in. On perusal of the records, we found that the Superintendent of Police Border Morigaon on 30/03/2011 initiated a case against one Haripod Kormokar, son of late Jubadish Kormokar of village Borka police station. Don't write that. লিখিছে না হরিপদ কর্মকার son of Jubadish Kormokar of village Moirabari police station Moirabari district Morigaon, Assam, being FTC number 104 of 2011. Suspecting him to be a foreign national, directing the sub-inspector police border of Moirabari police station to inquire into the matter. The concerned investigating authority accordingly investigate the matter And on 25/04/2011, investigating a matter only with regard to said or report Kormakar. And on 25/04/2011, submitted its report suspecting the nationality of said Haripat Karmakar. Submitting that the said suspect Haripat Karmakar might have entered into territory of India on or after 25/03/1971 as he failed to place relevant documents. Considering such report of the concerned investigating officer, like border police like within bracket border. The Superintendent of Police Border Morigaon, Assam on 30/03/2011. Can I give? কোন তারিখে দিতে পারি? 18 Don't write it. Twenty 11. Refer the matter to the Finance Tribunal, Morigaon. Under the provisions of the Finance within bracket Tribunal Order 1964 as amended. Railway নাই এই বস্তুবিলাক to determine they to determine as to whether said Haripada Karmakar and his family member are foreigners or not. Whether they have entered into India after 25/03/1971. Pursuant to such reference, of before mandate member for Superior Police Board of Morigaon, initially Foreigners Tribunal case number 2112/2012 was registered, which was later renumbered as FT 129/2016 before the Foreigners Tribunal number 5, Morigaon. On perusal of the records, we have also seen that notice under Order 4 under Order 4 and Order 2 of Foreigners Tribunal Order 1963 to 1964, the Foreigners Act 1946 was issued to said Haripad Karmakar only directing him to file his written reply of statement to appear and submit on 11/07/2016. Notice was issued on 9. It was issued on 9/6/2016. Behold, repeat your word. Which is, if you're Later, on 5/12/2016, the tribunal issued a press notice of said FT case number 12, of said case number FT 129 of 2016, to said Haripada Karmakar, as well as petition number 1, Meena Karmakar, Meera Karmakar, Meena Karmakar, এটা not. Petition number 2, Jiju Karmakar. Petitioner number 3, Mamoni Karmakar. And another, namely Lekha Karmakar. To submit their Mamoni Karmakar. No, petition number 3 ni likho. Petition number 3, Lekha Karmakar, and another, namely Mamoni Karmakar, directing them to appear before the tribunal on 26/12/2016 and to file their written statement. To prove the understand. The records of said FT case number 129 of 2016 of the Foreigners Tribunal, 5th Moringa, clearly reveals that initially the case was registered only with regard to Haripati Karmakar on 30/03/2011 in FTC number 104 of 2011. The inquiry in FT case number 104 of 2011 was only with regard to said Haripati Karmakar. The inquiry report, the concerned investigating officer, i.e. the Sub Inspector of Police, Moringa Board, dated 25/04/2011, in said FT case number 104 of 2011, as available in the case record, clearly reveals that after such inquiry, said Haripati Karmakar was considered to be suspected foreigner who had entered into India after 25. The records of FT 129 of 2016 of the Foreigners Tribunal of 5th Moringa doesn't contain any such inquiry with regard to the present petitioners. We have also seen that the tribunal, while accepting the reference made by the Superintendent of Police Board Hojai, sorry, Morigaon. With regard to said FT case number 104 of 2011. Without exercising its judicious mind and without making any inquiry from the referral authority, issued notice to the petitioners herein in said FT case number 129 of 2016, though there was no such investigation report against him. With regard to said FT case number 104 of 2011, it was initiated with sorry for the Karmakar, husband of petition number 1, father of petitioner. On being inquired, Mr. G. Sharma, standing counsel from department, from the record submitted that the reference made by the Superintendent Police Board, Morigaon, and the notice issued by the by the Foreigners Tribunal 5th Morigaon in case number FT 129 of 2016, arising out of FT case number 104 of 2011 to the petitioners. Without any material. And before issuing such notice to the petitioners on 5/12/2016 in said FT case number 129, the tribunal should have considered the materials as available in the record of the case, which the tribe did not consider. These are fairly tough. Since there was no proper inquiry and proper reference against the present petition, the impugn opinion plus order dated 30/08/2017 caused by the Foreigners Tribunal 5th Morigaon in case number F of holding the correct under the Foreigners Act. Illegally entered. Having entered the date of India within the on or after 25th. Being not sustainable in set aside cost with regard to the present petition. With regard to the according the interim order dated 27/08/2018 cost earlier in this specific stands for interim notice dated stands for. However, it is made clear that the concerned authority, after making necessary inquiry to the Superintendent of Police order, to the competent authority, Superintendent of Police, acha acha. May refer the matter to the concerned foreigners tribe regarding the nationality of academic nation. We have observation that to the extent that the registry shall return the records of application number 129 of 16. A copy of the sort forthwith to the foreigners tribunal in the fifth morning.
Deeply versed, my lord, deeply versed.
Lordship,
Mr.
regard-
Sharma, you have the report of
Yes.
item number 1.
yes, Lordship.
Yes, you are here.
21/10/2020, Lordship, petitioner was appeared.
One. Twenty-one ten,
2020,
he appeared.
yes, Lordship, he is now on bail, Lord.
Pursuant to our earlier order dated 09/04/2024. Mr. Z. Sharma, Standing Counsel, Home Department, on instruction submitted that in pursuance of the order dated 07, interim order dated 07/10/2020, the petitioner appeared before the Superintendent of Police Border, Barpeta, on 21/10/2020, and presently he is on bail in F.C. case number 91 of 2015, wherein the tribunal by the order dated 30/07/2018 opined the petitioner to be a foreigner under the Foreigners Act 1946 that illegally entered into the territory of India at some honor after 25 opportunity. Yes, you are. Will hear you. Record is here.
But not, they haven't prepared.
Why? Record is here. We'll pick up the matter. Start slowly. We'll see. If there is any adverse order required, we'll ask Mr. Roy to appear.
As of now, I know the facts. My lord.
Doesn't matter. You start. If the order is in your favor, we'll pass in your favor. If it is against you, then we'll ask Mr. Roy to be here.
My lord, kindly give me a short date. I will prepare well and appear.
Registry have already received the records of application number 91 of 2015 from the Foreigners Tribunal. It was called for by order 17. Give us a date. You give us a date.
24th May,
Too long. Next week,
17th.
16th, Thursday. Declare the council for the election. মই দুটা অৰ্ডাৰ উলিয়াব নাম্বাৰ কেইটা হেৰি প্ৰিণ্ট আউট কেইটা এই Yes, Mr. Vikas.
May I please your lordship? This is a contested case, my lord. Earlier interim order was passed and she was enlarged on bail. She was in detention camp, my lord. And thereafter, now FCR has come, my lord.
Yes, Mr. Naing, you will appear?
Yes,
Okay. Yesterday we have given you the records.
yes,
Have you gone through the records?
yes.
Please tell us. Take your seat, Mr. Vich.
The original reference was against this, my lord. Menu does. And she submitted WS and evidence as well, my lord. Sorry, my lord, I don't have the writ petition, copy of the writ petition.
You
But
can
the-
take
yes.
this, take this.
The- My lord, no, my lord,
Take it, take it. We will share.
exhibit A was my lord, no, I'm arguing from the,
You take that,
Record.
you will need it.
yes. The exhibit A was the voter list of 1971.
Okay.
And there it was, my lord. The voters were Girish Chandra Das. Lordship, uh, the page 19 of the report.
Yes, yes.
In fact, the voters were there in the 1971
Ah,
were my lord Girish Chandra Das, Gopal Das, Gopal, and Torubala Devi. And they were resident of my lord.
Garrison Das is projected father.
Yes, my
Urubala Day is the mother.
mother. And
Who is Gopal? Uncle.
Uncle,
that is, well, then you'll also will find the village is Urubonda Nonke.
Yes.
And Uruka
It is
Nonke
Purbonda Nonke,
Yes.
non-cadastral.
Yes.
Yes.
and Mauza was Laukwa, district was Nagaon.
Hmm.
That was the only voter list of 1971.
Hmm.
And then the certificate relied on by the petitioner is in the submitted by the before the tribunal was exhibit C. That is issued by the district Sonitpur office of the circle officer, Tezpur Revenue Circle. Here, my lord, the Minu Das, this is to certify that Minu Das, daughter of Sri Lake Gopal Das. Gopal Das was the father, my lord, not the Girish Minu. Gopal Das was projected to be the father.
Gopal Das is the father.
Yes,
And
Daughter of-
probably Girish Das is the grandfather.
grandfather. Daughter of Sri Gopal Das, father was Srimati
Torubala
Torubala Das,
Hmm.
mother. My lord, this is
Where-
ward number 12.
Ward, huh?
12 number ward under Tezpur Revenue Circle of Sonitpur district of Assam, who is aged about so years, was a resident within the jurisdiction of the state revenue circle and was of the state revenue circle. Srimati Minu Das got married on 11/5/1989. They to Sri Nikhil Das, son of so father of so Panumali Das, who are resident of Jamuguri village, ward number so revenue circle, Sonitpur district, Assam. As so, this is the marriage certificate and this is the link certificate.
Hmm.
They have submitted this document as link certificate. This is the only link certificate to link the petitioner along with Mother Gopal Das. Now disputed, Mother, the question now the only question, Mother, if we compare both this document, Mother, the exhibit A and C.
Hmm.
Exhibit A is of one Girish Chandra Das and one Gopal is there, Mother. we don't know, my lord, whether this Gopal is the same Gopal Chandra Das in exhibit C or not. That thing has to be established, first of all. And because this Gopal, who is in exhibit A, was a resident of Gurubanda Nonke, a village, my lord, of Nagaon district. And this Gopal, whom the petitioner is projecting as father in by this exhibit C.
So
it-
according to you, this exhibit C, annexure 6 in this petition
Yes,
is the link document
yes, madam.
placed by the petitioner
Yes, madam.
to prove her linkage with Gopal Das and Torubala Das.
Yes, madam.
And this certificate is been issued
In
from the circle
2015.
officer, Tezpur Southern
Tezpur
Revenue
Circle.
Circle,
Yes, madam.
whereas the projected father and mother
Yes.
of the petitioner
Were
were from village
Gurubanda
Gurubanda
Nanke of 1971. Who were,
Rupohiyar
yes,
Police Station
Rupohiyar Police Station, Mauda Laukpa,
and District Nagaon.
District Nagaon. Now, my lord, here your lordship may kindly see the certificate of 2015. This certificate was issued on 4th July 2015. But this facts which the certificate described is of 1989. Because,
No, if you read that certificate,
yes, ma'am.
you'll also see this certificate is issued based on the evidence placed before me.
Yes, that is definitely, my lord.
Okay.
What evidence they have produced.
But thing is this, you say that whether this Gopal Das
Yes,
and this Torubala Das is the same person
person
who
who
were
were there
resident
in
of- whose name figured in the voter list of 1970.
1971 at my lord different village, Gurubanda Nanke of
Oh.
Laukwa under Nagaon district. Because the address is totally different. My lord,
The
address,
proceeding did not deduce any evidence of her father, mother,
No,
or
no.
anyone.
no evidence of her father.
Okay.
This Minudas Gopal Das is a resident of my lord Tezpur Town. Ward number 12 of Tezpur Town.
She is the resident of
No.
Rohirri.
She
The certificate says, if you see, that was also initially we thought about, but thing is this, now you see, it is very clear that this is to certify that Minu Das, daughter of Sasan Chach Ratan Chach, of 12, number 12, ward number 12, under Tezpur Revenue Circular, Sonitpur, the resident within this jurisdiction, and she got
Was a
married on
resident.
Ivani Maniman.
Yes.
That's all. That's how it has been placed. It is
married
not
to
because Gopal Das already expired.
married to my lord to married to Nikhil
Nikhil
Das,
Das.
son of so and so of village Jamuguri.
They're presently residing in
Yes.
that circle. Nothing about the resident of Gopal Das or Turubala Das.
So your lordship, for that, my lord, your lordship may kindly see the WS. What is there in the
Just
WS?
a minute. No. So according to the tribunal, the proceeding could not prove her linkage with
Projected
the
father.
said Gopal Das and Turubala Das of village Gulbanda.
Yes, ma'am.
Written statement hasn't been annexed in the.
Yes, it is in records, madam. May I read?
Kindly read, kindly read.
Yes. May I read, madam? That the অপৰিপক্ষৰ লিখিত জবাব অপৰিপক্ষ মাননীয় আদালতত লিখিত জবাব এই যে উপৰোক্ত গোচৰত অপৰিপক্ষ কোনো প্ৰকাৰে জড়িত নহয় এই গোচৰ সম্পূৰ্ণ মিছা আৰু ভিত্তিহীন তদন্তকাৰী বিষয়াই তদন্তৰ সময়ত কোনো সঠিকভাৱে তদন্ত নকৰি কোনো যাৱতীয় নথিপত্ৰ নোচোৱাকৈ অপৰিপক্ষৰ ওপৰত এই গোচৰ ধৰিছে প্ৰমাণ আছে যে অপৰিপক্ষৰ পিতৃ গোপাল পিতা গিৰিশ চাং ভিলেজ বুৰবন্দা ননকে মৌজা লাওখোৱা জিলা নগাঁও স্থায়ী বাসিন্দা আছিল উক্ত ঠিকনাত অপৰিপক্ষৰ জন্ম হয় আৰু ডাঙৰ দীঘল হয় So she was born and brought up in this place. প্ৰকাশ থাকে যে পৰৱৰ্তী সময়ত অপৰিপক্ষৰ শ্ৰী নিৰ্মল দাস পক্ষক শ্ৰী নিৰ্মল দাস পিতা ৰমেশ দাস গাঁও প্ৰাচী গাঁও মৌজা চিলাবন্ধা থানা বায়ুজুৰি জিলা শোণিতপুৰৰ লগত বিয়া হয় বিয়াৰ পিছৰ পৰা অপৰিপক্ষ উক্ত ঠিকনাত স্থায়ীভাৱে বসবাস কৰি আছে So she is permanently residing in that village, madam. Village Prasigao, Moja Jilabonda, Thana Bayujuri. প্ৰকাশ থাকে যে অপৰিপক্ষৰ ককা দেউতাক আৰু দেউতাৰ 1971 চনত 90 নং কলিয়াবৰ বিধানসভা সমষ্টিত খণ্ড নং ইমান প্ৰদেশ অসম জিলা নগাঁও থানা ৰূপহী ক্ৰমিক নং 725 আৰু 26 ভোটদান কৰিছিল আজি অপৰিপক্ষই উক্ত বৰ্ষৰ ভোটাৰৰ প্ৰত্যয়িত নকল মাননীয় আদালতত দাখিল কৰিছে প্ৰকাশ থাকে যে অপৰিপক্ষই নিজে 1997 চনত 75 নং চতিয়া বিধানসভা সমষ্টিত ভোট গ্ৰহণ কেন্দ্ৰৰ নং ইমান ভোট গ্ৰহণ কেন্দ্ৰৰ নাম ইমান ভৈৰৱী প্ৰাথমিক বিদ্যালয় খণ্ড নং 63 ক্ৰমিক নং 342 খ নং 62 ভোট কৰিছে আজি মাননীয় আদালতত উক্ত ভোটাৰ লিষ্ট দাখিল কৰিছে 1997 ভোটাৰ লিষ্ট was submitted প্ৰকাশ থাকে যে অপৰিপক্ষই নিজৰ দেউতাৰ লগত সম্বন্ধ প্ৰদৰ্শন কৰিবলৈ বৰ্তমান এনআৰচি সন্দৰ্ভত ৰাজচক্ৰ বিষয়ে প্ৰদান কৰা এখন নথি দাখিল কৰিছে উক্ত নথিত অপৰিপক্ষ মৃত গোপাল দাসৰ কন্যা বুলি উল্লেখ আছে এই অপৰিপক্ষৰ কোনো কাৰণতে অবৈধ ভাৰতীয় নাগৰিক নহয় পিতৃ আৰু ককা দেউতাৰ দিনৰ পৰা ভাৰতবৰ্ষত বসবাস কৰি স্থায়ীভাৱে থকা ভাৰতীয় নাগৰিক হয় এইমতে প্ৰাৰ্থনা দয়া কৰি মাননীয় আদালতে অপৰিপক্ষৰ সমূহ যাৱতীয় নথিপত্ৰ চালি জাৰি চাই অপৰিপক্ষক বৈধ ভাৰতীয় নাগৰিক বুলি ঘোষণা কৰিলে So only document was the 1971 97 voter list and the valid certificate which the petitioner has executed and this statement two things matter first of all no this is in the WS what is there in the WS she has clearly said after marriage she has been residing in para 4 manner প্ৰকাশ থাকে যে পৰৱৰ্তী সময়ত তাই অপৰিপক্ষৰ শ্ৰী নিৰ্মল দাস পিতা মৃত ৰমেশ দাস চাং প্ৰাচী গাঁও মৌজা চিলাবন্ধা থানা বায়ুজুৰি জিলা শোণিতপুৰৰ লগত বিয়া হয় বিয়াৰ পিছৰ পৰা অপৰিপক্ষ উক্ত স্থানত ঠিকনাত স্থায়ীভাৱে বসবাস কৰি আছে So she is residing of this area, madam. So by no means, my lord, neither the parent nor her residence is shown like the mother to exhibit C, madam. Exhibit C is a different. Exhibit C is of my lord of different place. So she has nowhere
First,
stated.
to whom the notice was issued?
Notice address was my lord. Minu Das, wife of Nikhil Das, village Panpurghat, Jamuguri.
Okay. what was the address given by her in her written statement? While showing the affidavit, verification and the affidavit page.
No, no affidavit is shown, Manoj. No verification is there. No verification, no. No verification. He has given her oral statement, Manoj. Evidence. Let us read the evidence of the Manoj DW1. As per this oral statement, Manoj, oral evidence of DW1, he is a resident of Papughat, Jamuguri Hat.
Mail. It is before copy. No, equity building to be one. Any witness on the record?
Witness of DW1 and DW2 may read the report.
Please.
DW1, Madam, this is Minu Das herself. She is resident of village as per her statement, Papunghat, Jamuguri Hat, Madam. On oath. My father, late Gopal Das, son of late Girish Das, was a resident of Burmanda, Nokula, Moja, Laukwa, Nagaon, Assam. I was born and brought up in the said place. After her marriage, after maturity, I got married to Sri Nikhil Das, son of late Ramesh Das of village Pasigaon, Moja, Silbanga district, Sonitpur, Assam, and since then I am residing in the address. My grandfather and father's name has been shown in the voter list of 1971 from 90 number Kaliabor constituency by serial number so-and-so, respectively, house number so-and-so. My name has been shown in the voter list of 1997 of 75 number Sotia LAC, part number so-and-so, serial number so-and-so, house number so-and-so. Exhibit A is the voter list of 1971. Exhibit B is the voter list of 1997. Exhibit C is the certificate issued by the circle officer of Tezpur Revenue Circle, District Sonitpur, Assam. So these are the three certificates, documents she exhibited. In cross, she has said, I have no other documents to prove my citizenship other than then I submitted before the court. It is not a fact that I deposed false evidence. So she has admitted she has no other documents, my lord, except these 3 documents. Now DW2. DW2 is the project said to be the mother, uncle of the Minu Das. He is Sivas Das. He was not in the voter list of 1971. This Sivas Das. Sivas Das, village Burbanda, police station Ulwani, my lord, and district Nagaon, post office Borgoli. The Sivas Das is the resident of that area, my lord. On order. Procedure Srimati Minu Das is the daughter of my younger brother. My younger brother, Minu Das. Minu Das was born at Borghat at Tezpur. Was born and brought up at Tezpur. He was born and brought up at Tezpur. The father name of Minu Das is late Gopal Das. He is married to Panpur village of Nikhil Das. Since her marriage, she is staying in the said locality at Panpur under Jamuguri police station. I have been casting vote regularly from 1989, from 89 Kaliabor LSC, by part number so and so, voter ID number so and so, issued to me by card number so and so. Exhibit D is the said voter ID card. I do not know the name of the wife of brother late Gopal Das. Exhibit E is the voter list of 1960. So they have contradicted themselves, my lord. First of all, the DW1, the proceedee herself in WS has not stated anything about his, my lord, uncle. And secondly, my lord, this uncle has said, even though the petitioner proceedee in WS as well as in my lord evidence said that she was born and brought up in Nagaon district, but the uncle has said she was born and brought up at Tezpur. And the certificate which is issued, which is relied on, the documentary evidence, my lord, is of Tezpur. And there is
Yes. Yes, Mr. Biswas.
Yes, my lord.
How do you prove your link now?
My lord, I take your lordship page 13. In the 1959, there was an eviction notice into my grandfather. Page 13, Annex 1. At this Burbanda, my lord, under Nagaon district, my lord. And my lord, Burbanda and Tezpur is just a breeze now. Earlier, there were, when they have brought up, it was breeze has already developed, completed, my lord. It is this bank and that bank, South Bank and North Bank. And that is the eviction notice issued by the Deputy Commissioner in 1959 to my grandfather. So it proves that we are there since 1959 at Burbanda.
No. Existence of Girish Das, existence of Gopal Das,
Yes.
existence of Urubala Das, at village Burbanda, fine. They existed.
And NRC you will find 71 is there also,
They
Please.
existed.
16.
What is your link with Gopal Das? That is what Mr. Payang is asking,
Yes.
because by that certificate, petitioner had established that she is daughter of such and such, fine. But
Yes.
daughter of Gopal Das and Torubala Das of which place? It is not there.
My lord, there is a school certificate, page 20,
Now, in the school certificate also we have mentioned, you just see,
Gurbanda.
fine.
Yes.
Where is that year?
Here is issued on 23/3/17,
That is more
and she
difficult.
was a student of, she was
Of which
born
year?
on 5th February
See, there is a
1959.
gap. In which year she left that school? First of all, this document was not proved.
Yes, it was not proved, that
And
is true.
secondly, it was issued on 23rd of March 2017.
Yes, that's also I admit, my lord.
And there is no mention when did she leave that particular school? Which year? Then
Studied in the school on
if
31st
it is a
December, my lord.
certificate, then it is a late Gopal Das and late Torubala Das.
Yes. It is the fact that she has lost her parents, my lord. Then, my lord,
While the admission was there in the school, her parents were not there.
my lord, as per the certificate, it shows that it is a late, my lord. Both late Gopal Das
That's the
and
reason we are asking you.
probably, my lord, 17 it was late, my lord. Earlier it was not late, my lord, probably.
So true, but that is the reason we want to know. If you see that gap after NC Bhurwandha,
Yes,
প্রাথমিক বিদ্যালয়ত পঢ়িছিল ইংৰাজী দেন গেপ চনৰ ডিচেম্বৰ মাহৰ 31 তাৰিখত এই বিদ্যালয়ত তেওঁ শেষ হ'ল which year
it is also not actually
secondly,
given, my lord. That's true.
leaving aside there is a
It is a
national
mistake
emblem
done
is
by
there.
headmaster. my lord.
national emblem is there, this particular teacher was not,
Emblem, my lord, it is the ignorance of the headmaster.
no, cannot be. Now thing is this, secondly, this particular headmaster did not adduce any evidence,
He was not brought.
In fact, this was not submitted
is-
before the tribunal, my lord.
or this was not submitted before the tribunal.
This was not.
Then, my lord, regarding circle officer certificate,
Hmm.
it is also
Circle
proved that
officer did not mention one thing. If the circle officer certificate to be accepted, had been saying that Gopal Das and Torubala Das resident of such and such,
that is of,
that could have. Now, we do not know whether this Gopal Das and Torubala Das was of from village Purvandha or not.
my lord,
This
own,
certificate doesn't add anything.
own uncle has deposed as DW2. She also deposed that she is also from Gurbanda.
See,
Gurbanda, my lord.
This was the person who has deposed on behalf of the proceeding. His name did not figure in the voter list along with Gopal Das or Torubala Das.
She was probably not attained the majority, that's why
Who?
this Minu Das.
Not about talking about Mindu Das, talking about the
Giris Das.
uncle who adduced evidence,
His name is there, voter list.
No,
Gopal Das is there.
in which Gopal Das's brother who have adduced evidence as DW2,
Of course. Yes, yes.
whether his name figured in the voter list of 1971,
But he said that I am in the voter list.
whether in the written reply submitted by the proceedee mentioned that Giris Das had this, or the Gopal Das, his father had these siblings,
My lord,
whether it was mentioned.
in the written state, it is not mentioned that.
The difficulty is the proceedee. All this knowledge belongs to the proceedee and nobody else. Unless it is mentioned in the written reply, how will you able to straight away can come into evidence and say this?
That is
And that
there.
also without any documentary evidence. See, with regard to this, the foreigner, what the Honorable Apex Court had said, the document, whatever is placed, has to be reliable, acceptable, and truthful. Where is that?
That is true. That is true, but I admit.
Otherwise, it's anyone can give any document.
But land document also there, my lord, page 20.
True, that we have seen, but land document. of
Jamabandi,
Where is the link that you are from Bhurbandha? How you have proved that?
except her own
Existence of.
her evidence and uncle's evidence
See,
that they are originally from Bhurbanda.
is the thing we are asking. There has to be linked document. There has to be documentary evidence.
It's true.
Now, there is no one denying the fact that existence of Gopal Das or Torubala Das and one Giris Das at Bhurbandha in the 71. There is no.
Yes.
But whether this Gopal Das is the father of the Prosody, where is that link?
In that event, matter, I will pray that let the matter be remanded
How
back.
come? We are not here to remand the matter back. That could have prayed before the tribunal. That is why we are always asking you, the go to the recent judgment of the Honorable Apex Court passed in last August. Where is our power? No such power. We are not sitting here for mandamus or certiorari. Sorry, no, quarantu. We are here only for certiorari to see that the order of the tribunal is good or bad. To that extent only.
In fact, DW2 has said, my lord, as I have said, read, my lord, Minu Das was born and brought up at Tezpur, not at Gurgaon. So the two different statements. The procedure
No,
has
the
said,
difficulty is, proceed, brought
Even-
someone to adduce evidence on her behalf.
yes. And interestingly, the DW2 does not know the mother name of the petitioner.
Maybe
that is
you
also-
cannot expect everything from the drastic.
Definitely, how come?
I don't know.
Sister-in-law's name is not known if he is a family member. It is difficult.
My lord, always it is not possible also, my lord, to keep the name of the remembering. Even if your lordship asks me, I cannot say all the name of family members.
Hey, if you have 14, 15 brothers, sisters, that is a different case. But if you have small family member, why will you not remember?
One exhibit E was exhibited by the DW2, that is in record, my lord. It says one Bipin Chandra Das, the voter list of 1965, where one Bipin Chandra Das is appearing, showing relationship name is Bhulanath. It is not the name in the name of Sibes Das. Sibes Das has said in my lord,
The best das is son of Bipin Chandra Das.
no, not Sibes Das, my lord. He has said exhibit E is the voter list of 1965. That means want to show it, but in 1965 voter list, what he has submitted, this is exhibit E. Exhibit E. It is one Bipin Chandra Das, son of Bhulanath.
Bhola Das.
Bhula.
Bhola Das.
Which village? Which village?
This is a Bhurbanda, not
Gurubanda.
but this is not Sibes Das, my lord, who has come before the tribunals. He has submitted these documents saying that it is his voter list. But this is a
Whatever document they got, they place it to prove her nationality.
but this is a Bhupen Chandra Das.
Bhupen, no?
Bipin Chandra Das.
Yes, Bipin Chandra. Bipin Chandra Das to naam hai.
No, he is Sibes Das, DW1, DW2. And as per the Sibes Das matter, the father of the petitioner is the younger brother of the petitioner, the DWC. So his name should have been there in 65, 70, along with
Anything else?
No, I have nothing to say. I leave it to your lordship.
Now tell us where is the petitioner, because earlier she was in detention camp.
Hey, she was released by the honorable court.
When,
Now she is the husband at Jamaguri.
when she was released from the detention camp.
After a
During
long gap.
COVID
This is
or-
the record matter.
No. There is no record. No bail order was passed in her case. Probably during the time of COVID or
COVID.
But probably after 3 years then she has been released. But she was released on.
Okay.
And presently I have no knowledge whether she is alive or not also. The matter released in 2017.
pass on the record. Mr.
three. Yes, sir. They do. Yes, the judgment.
Take your seats, take your seats. Very well. Anyway. Yeah. Very well. Uh, No problem. Take it. Okay. Heard Mr. S.C. Biswas, counsel appearing for the petitioner. Mr. U.K. Goswami, learned physically for the response. Also heard Mr. J. Paying, standing counsel from the partner, for the response 2 and 4, as well as Mr. P. Sharma, as a chair. And an additional senior governor, some for the response. Pursuant to the order to the 3105/2017 registered, no. Pursuant to- Peruse the record of application number FTC, within bracket 6, bracket close 17/2015 of the Foreigners Tribunal 6, test code Foreigners Tribunal 6, Sonipur, Tezpur, at Sutia, at the Bull OTA, erstwhile district Sonitpur, presently Bishwanath. From the petition, we have seen that the proceeding after the impugn order that 15/02/2017 was taken into custody and detained, was into custody and kept in the detention Passport jail. However, on being inquired, Mr. Biswas and counsel for the petitioner submitted that later the proceeding was released from detention. Arguments are heard. Order is up.
What was that? 2019. 2019, 1 GLT 784.
Just a minute, Mr. Let's note. After perusal of the record, we have perused it, before that, we have perused the records such and such, that was called for. After perusal of the record, Mr. J. Pai, sorry, Mr. G. Sharma, standing counsel, Home Department, returned the same to the court. That's one. Yes, Mr. Pai, you have said,
2019, 1 GLT 784.
for what purpose?
That with regard to the melody, made it
2019,
2019, 1 GLT 784. This I'm reading small 2-paragraph melody.
Hmm.
As corollary, any evidence being laid to discharge of such burden of proof, we should indicate the lineage of proceeding to a person merely having the same or similar name as that of the person appearing in the public documents relied upon, in our view, would not be sufficient to discharge of the burden of proof to establish the existence of the fact that the person named in the referred public documents constitute the lineage of the proceeding. Then, my lord, in order to discharge the complete burden of proof, the nature of proof of the evidence must be such that the lineage established not only with respect to the person whose name appears in the public documents relied upon, but at the same time rules out the possibility of it being linked to any other person having a similar or same name. So, because she is trying to link herself with the voter list of 1961, so for that purpose, published.
মানুহ এটা থাকবা নিদিবি হা চব মানুহ পঠাই দিব
yes, that's state appeal, state writ petition. Yes. Let us read the order first, the impugn order.
President. Present reference has been made under provisions of Section 21A of the Foreigners Tribunal Order 1964 against the opposite party proceedee, hereinafter called as proceedee, namely Masammat Fulmala Begum, wife of Muhammad Jinnat Ali Ahmed, of village number 2 Kaplabari PS Mukalmoa district Nalbari Assam, suspecting her to be a foreigner who illegally entered into India after 25th day of March 1971 through unauthorized route due to poverty from village Masbak PS Kiseriganj district Moimansingh of Bangladesh and started living at village number 2 Kaplabari under Mukalmoa police station of Nalbari district. During the course of enquiry, the enquiry officer interrogated the proceedee and also took her statement along with two other independent witnesses of number 2 Kaplabari village, namely Sarban Begum, wife of Akbar Ali, and Bulbuli Begum, daughter of Akbar Ali. Thereafter, on the basis of enquiry report, the competent authority suspected that proceedee is a foreigner. Accordingly, reference was made and forwarded to the Foreigners Tribunal Nalbari for trial. After establishment of this tribunal along with two others, Foreigners Tribunal Nalbari has transferred the case record to this tribunal for disposal. I have gone through the case record and prima facie satisfied that there is a ground for reference against the proceedee. Accordingly, notice was issued upon the proceedee. Notice was duly served upon the proceedee. Accordingly, proceedee entered his appearance along with his engaged counsel and contested the case by filing written statement claiming to be a citizen of India by birth. Now, here the point for determination is as to whether the proceedee is a foreigner within the meaning of the expression foreigner as defined in the Foreigners Act 1946 or not. Since as per provisions of Section 9 of the Foreigners Act 1946, burden lies upon the proceedee to prove that he is a citizen of India, not foreigner. Now let us examine as to whether the proceedee could discharge his burden to prove that he is not a foreigner. Proceedee examined 5 witnesses, including himself, exhibited 4 numbers of documents in support of her claim to be a citizen of India. In her deposition, proceedee deposed that her name is Fulmala Begum, wife of Jinnat Ali Ahmed, and daughter of late Hussein Ali of village number 2 Kaplabari, and is a citizen of India by birth. She was born on 1/7/1983, according to her school certificate. She brought up at village Akadi under Hajo police station of Kamrup district. Exhibit 1 is the photocopy of school certificate, which is proved in original. Her marriage was solemnized on 10/8/2000 with Jinnat Ali Ahmed of village number 2 Kaplabari, and since then she is living with her husband. Her father's name recorded in the voter list of the year 1966 as Hussein Ali, son of Kebez, in village Puran Taprapara under 61 number Hajo LAC Fight part number 24 Ko house number 25 serial number 76. Exhibit 2 is the photocopy of the said voter list which is proved in original. Her father's name also enlisted in the voter list of 1970 as Hussein Ali, son of Kabez of village Kalarsor, PS Nalbari, under 54 number Senga LAC, fight part number 25, house number 427, serial number 464. Her father's name also enlisted in the voter list of the year 1997 as Hussein Ali, son of Kabez of village Akadi, under Hajo police station, fight part number 52, house number 139, serial number 398. Exhibit 3 is the photocopy of state voter list, which is proved in original. Proceedee further deposed that her name enlisted in the voter list of the year 2010 as Fulmala Begum, fight part number 43 of 60 number Borkhetri LAC, house number 193, serial number 620 of village number 2 Kaplabari. Exhibit 4 is photocopy of state voter list which is proof in original. During cross-examination, proceeded deposed that residence of her father is in Akadi village under Hajo police station. Her father's name is Hussein Ali. He is expired. Her husband name is Jinnat Ali Ahmed. Now she is residing in number 2 Kaplabari. Name of her father-in-law is Rahimuddin Akan. She is casting vote since 2010 from Borketri constituency. Name of village headman of number 2 Kaplabari village is Jayanta Medhi. She does not know that her father-in-law's name has been wrongly recorded in voter list. She has not submitted any application for correction of the same. Name of her mother-in-law enlisted in the voter list. Her name is Maijan. She has not submitted any certificate from the village settlement of her father's village. She has submitted NRC document. On examination by the court, proceeded deposed that she was reading up to class 9 at Kanbari High Madrasa. Name of her mother is Zahira Khatun. Her father's name is Hussein Ali. About 3 years ago, he expired. Her grandfather's name is Kabes. Name of her elder brother are Joinal Ali and Ainul Haq. She has submitted photocopies of voter list of 1970, 1985, 1989, 2005, and 2012. She has not obtained certified copies of the same. Neither police personnel went to her house for investigation nor took her statement. Sarban Begum and Bulbuli had given false statement before the police. OPW 2, namely Ramani Sharma, authorized person of election officer Nalbari, deposed that name of Hussein Ali, son of Kabes, appeared in the voter list of the year 1966 under 61 No Hajo Legislative Assembly constituency of village Puran Saprapara, Vice serial number 76, house number 25, part number 24, age 35 years. OPW further voter list of the year 1970 of Kalasar is not available in their office. Further. OPW 3, namely Muhammad Asimuddin Ahmed, in-charge superintendent of Kanbari High Madrasa, deposed that he is working as in-charge superintendent of Kanbari High Madrasa. In the year 1984, he was appointed as assistant teacher of the said madrasa. Madrasa was provincialized in the year 1997. He further deposed that he has brought the admission register for the year 1984 to 2002 and attendance register for the year 1999. As per the admission register of the year 1998, Fulmala Begum had taken admission of their madrasa in class 8. Her admission serial number is 805. As per admission register, her date of birth is 1/7/1983. It is seen that Fulmala Begum was reading in their madrasa up to class 9. As per the daily attendance register, she was present in class 9. The certificate issued in her favor was signed by earlier superintendent. He identified the signature. It is confirmed that the signature appeared in the certificate is his signature. Name of earlier superintendent was Mujibur Rahman. He retired in the month of February 2015. Cross-examination was declined by learned assistant government leader OPW 4 Muhammad Habibur Rahman, village settlement, deposed that it is true that he has issued a certificate in favor of Fulmala Begum. He knows Fulmala since her birth. Name of Fulmala's father is Hussein Ali. His residence is in Akadi village. He knew Hussein Ali. He is the village settlement of Kumarpur, Hirajani, and Akadi village. Father's name of Hussein Ali is Kabez Ali. He did not see Kabez Ali. He knows that marriage of Fulmala was solemnized with Jinnat Ali, son of Brahim Ali. Now Fulmala is not residing at village Akadi. After her marriage, she is residing in her husband's house. During cross-examination, OPW 4 deposed that Fulmala personally went to his house to bring the certificate. Due to mistake, he has written in the certificate that Phulmala is permanently residing in village Akadi village. He was not present in marriage ceremony of Phulmala. I have heard Mr. Amiruddin Learned Counsel appearing for the proceeding and Mrs. M. Puya, Learned Assistant Government Leader. During the course of argument, Learned Counsel for the proceeding produced some additional documents. Original copy of NRC 1951 of the father of the proceeding, issued by the Insurance President, Kamrup District, Jamiat Ulema in Hind, dated 11/3/1961. Photocopy of voter list of the year 1970 of village Kalarsor. Second part, under 54 numbers, Senga LSE. Photocopy of sale deed number 465 dated 2/3/1985 in the name of the father of the proceeding. 4 certified copies of voter list of the year 2005 and 2008, wherein name of the proceeding appeared as voter in village number 2 Kaplabari under 60 number Borkhetri LSE, and submits that name of Hussein Ali, that is father of the proceeding, recorded in the NRC 1951, voter list of 1966 and 1970 as voter under 54 number Senga LSE, being a citizen of India. Learned Counsel further submits that proceeding was born and brought up at village Akandi under Hajo PS, and her date of birth is 1/7/1983. Therefore, as per section 682 of the Citizenship Amendment Act, proceeding is a citizen of India by birth, being a daughter of Hussein Ali, alias Hussein Ali, son of Kabez. OPW 2 proved that name of Hussein Ali, son of Kabez, recorded in the voter list of the year 1966. Learned Counsel also submits that father's name of the proceeding recorded in the voter list of the year 1985, 89, and 97 as continuity. Exhibit 1 and the certificate issued by the village settlement of Akandi village shall prove the relationship of the proceeding with Hussein Ali as her father. OPW 3 in his deposition clearly deposed that proceeding was admitted in their Madrasa in the year 1998 and left the Madrasa in the year 2000. She was reading up to class 9. As per admission register, her date of birth is 1/7/1983. Exhibit 4 and voter list of the year 2005 and 2008 shall prove the relationship of the proceeding with Jinnat Ali Ahmed, son of Brahim, as husband and wife. Other OPWs shall prove that they know the proceeding and her father Hussein Ali, as well as her husband Jinnat Ali Ahmed. Learned Counsel further submits that proceeding in her deposition deposed that her father's name is Hussein Ali and mother's name is Zahira Khatun, which is corroborated with the evidence of OPWs and documents available on record, shall prove that proceeding is the daughter of Hussein Ali, alias Hussein Ali, son of Kabez, whose name enlisted in NRC 1951 voter list of the year 1966, 17, 1985, 89, and 97. Learned Counsel submits that enquiry officer did not investigate the matter properly by spot verification. Learned Counsel further submits that without proper and fair investigation, enquiry officer submitted his report suspecting that proceeding is a foreigner. In support of his argument, Learned Counsel relied upon paragraph 72 and 73 of Muslim Mandal Supra, reported in 2013 1 GLT 809, and paragraph 10 of the judgment dated 8/11/2013, passed by Division Bench of the Honorable High Court in Abdul Matali, alias Matleb, case reported in 2015 2 GLT 617. Accordingly, he placed for dismissal of the reference case, declaring the proceeding as a citizen of India by birth. On the other hand, Learned Assistant Government Pleader submits that there is some discrepancies in the name of the father and grandfather of the proceeding. In some documents, father's name of the proceeding recorded as Hussein Ali, and in some documents, Hussein Ali, and in some documents as Hussein Mondal. Similarly, in some documents, father's name of Hussein Ali shown as Kabez. In some documents, Kabez Ali and son, and in some documents as Kabez Mondal. However, proceeding failed to prove that Hussein Ali is one and same person. Similarly, proceeding also failed to prove that Kabez Ali and Kabez Mondal is one and same person. Hence, doubts creates in respect of the father and grandfather's name of the proceedee whose name recorded in the NRC 1951 and voter list of the year 1966 and 1970. Learned assistant government leader further submits that at the time of inquiry, proceedee failed to produce any valid documents in respect of her Indian citizenship before the inquiry officer, in spite of getting adequate opportunity. Now producing some documents of herself, her father, mother, and grandfather, proceedee cannot claim her citizenship by birth. Therefore, learned assistant government leader praised for declaring the proceedee as foreigner by showing the reference case, by allowing the reference case. I have gone through the reference report of the inquiry officer and statements of the proceeding and other witnesses recorded by the inquiry officer. I have also produced the written statement, evidence of the proceeding and other witnesses and documents exhibited and produced by the proceeding. Voter list of the year 1966 and 1970 revealed the name of Hussein Ali, son of Kabez under 54 Sengal Legislative Assembly constituency as a voter, being citizen of India. OPW2 confirms the name of Hussein Ali, son of Kabez, appeared in the voter list of 1966. Evidence of OPW 1, 3, and 4 corroborated in respect of father's name of the proceedee. Other documents as well as voter list revealed the name of Hussein Ali, son of Kabez, as continuity. Exhibit 1 and certificate issued by the village settlement of Akandi village reveal the relationship of the proceedee with Hussein Ali alias Hassan Ali alias Hassan Mondal as father and daughter. Proceedee in her deposition deposed that her mother's name is Zahira Khatun, name of Zahira Khatun, wife of Hassan, recorded in the voter list of the year 1970 under 54 number Senga Legislative Assembly, Senga LSE of village Kalarsor, second part by serial number so and so. Proceedee also proved that she is the wife of Jinnat Ali Ahmed and her name enlisted in the voter list of the year 2005, 2008, 2010, and 2014 under 60 number Borkhetri Legislative Assembly constituency. In view of discussions made above, proceedee established that she is the daughter of Hussein Ali alias Hussein Ali, whose name recorded in Exhibit 1, voter list of the year 1966, 1970, and 1997, and wife of Jinnat Ali Ahmed. Therefore, in my considered view, proceedee could discharge her burden as proof, burden of proof as envisaged under Section 9 of the Foreigners Act 1946. Accordingly, in my opinion, the proceeding, namely Masamat Fulmala Begum, wife of Jinnat Ali Ahmed, daughter of Hussein Ali, of village number 2 Kaplabari PS, Mukalmua district, Nalbari, is not a foreigner. The reference is answered accordingly, inform accordingly.
So what is your first ground? Why this order should be interpreted?
Lordship, my humble submission is that, Lordship, there is an error apparent on the face of the opinion, which is not tenable in law.
Tell us one by
And
one.
findings of the learned tribunal is not based on evidence on record, and respondent failed to discharge her burden by bringing admissible, reliable, and present evidence. The learned tribunal ignored the materials on record and come to a wrong conclusion that the respondent is not a foreigner. which is contrary to the law as well as i- interest of the state, Lordship. Lordship, here in this case, proceeding exhibited Exhibit 1, which is the school certificate, Lordship, which is proved in
Just,
which
just,
record is with me, Lordship.
and
W. Okay. Okay. Lordship, may I go to the WS, Lordship? May I read, Lordship? WS.
no, you tell us your contentions first, then we'll go to the materials.
Yes, Lordship.
So according to you, the tribunal, where is the illegality, one by one?
Hmm? No. Here, Lordship, Exhibit 1 is the photocopy of the school certificate, Lordship. Hmm? Okay. Hmm.
Yes. Exhibit 1, school
it-
certificate.
Yes, Lordship.
Now,
Where's in school certificate, Lordship? Lord,
proved or not proved?
it was proved, Lordship, but where it it was written that Fulmala Begum, daughter of Muhammad Hussain Ali, an inhabitant of village Kapkata, P.S. Mukalmua, PUNPS Mukalmua in the district of Nalbari, left the school
Village,
village Kapkata, Lordship.
SAP.
Yes, Lordship.
Okay.
Village Kapkata. Whereas petitioner stated that Lordship
Born
is
and
the
brought up,
resident
born
at
and
village
brought up at which village?
Akandi. He never stated anywhere, Lordship, that was an inhabitant of Sapkata, Lordship.
Okay, fine. Then
Then, Lordship, in 1966 voter list,
exhibit,
Exhibit 2,
yes,
it is of village Puran Saprapara.
Hmm.
Here, proceeding this voter list, as per proceeding, his projected father's name is reflected in this voter list, Lordship.
Hmm.
Then, Lordship, proceeding, although relies on 1970 voter list, Lordship,
which exhibit?
it was not exhibited, Lordship. It was placed during the time of agreement, a photocopy of this voter list, Lordship. Photocopy of 1970 voter list has been placed before the learned tribunal,
It was not exhibited.
not exhibited.
Voter list 1970 photocopy.
Yes, Lordship.
Okay.
Then exhibit 3 is the 1997 voter list of village Akandi.
Okay. Now, 1970 voter list, which was not exhibited before the tribunal, the
Hmm.
photocopy was placed.
Hmm.
That belongs to which village?
That belongs to Lordship, village color, sir.
Okay.
That was considered by the tribunal.
In the order, the tribunal has written that.
Yes, Lordship.
That is why we ask you to read the judgment, right?
Yes, Lordship.
What we have seen from the order, the tribunal has considered this, that 1966 voter list, 1970 voter list, and the subsequent voter list
Yes, Lordship.
that consists of 3 different villages.
And Lordship, then exhibit 3 is the 1997 voter list
Of whom?
of Lordship Hussein Ali, projected father's name appeared and her mother's name as Zohira Khatun of village Ekadi.
Akandi or Ekadi?
Here it was written as Ekadi.
EKA. In English or Assamese?
In Assamese, A,
Ah,
Potakar, Doinka do, Usuikar.
okay. Okay. In 1966, Hussein Ali's name figured at village Puran
Puran
Saprapara.
Saprapara.
And then in 1970, it's,
Kalar sir.
but that's not a certified copy.
That's not a certified copy.
Then in 1997, village Ekadi or Akadi, whatever you say,
Ekadi, yes, Lord.
petitioner's father and petitioner's mother.
Reflected. Then, and regarding 1970 voter list, what election officer has submitted, Lordship, give evidence, Lordship. I want to read, Lordship.
DW
DW 3, Lordship.
3, relating to voter list of 1970.
Yes, Lordship.
What is his deposition?
মই নিৰ্বাচনী বিষয়া নলবাৰীৰ অথৰাইজ ব্যক্তি হিচাপে আজি এই গোচৰ সাক্ষী দিবলৈ আহিছো। আদালতৰ নিৰ্দেশ মৰ্মে 1970 চনৰ 54 নং চেঙা সমষ্টিৰ কালাৰছৰ গাঁৱৰ আৰু 1985 চনৰ 60 নং বৰক্ষেত্ৰী সমষ্টিৰ সাপকাটা গাঁৱৰ ভোটাৰ তালিকা লগত আনিছো। 1989 চনৰ ভোটাৰ তালিকা অফিচত এভেইলেবল নাই। 1970 চনৰ আৰু 1985 চনৰ যি ভোটাৰ তালিকা অপৰপক্ষই আদালতত জমা দিছে সেই তালিকাৰ ক্ৰমিক নম্বৰ আৰু ঘৰৰ নম্বৰৰ লগত মই অনা ভোটাৰ তালিকাৰ মিল নাই। And tribunal considered this evidence of the election officer, Lordship.
House number and serial number.
Yes, Lordship. যি 1970 চনৰ আৰু 1985 চনৰ যি ভোটাৰ তালিকা অপৰপক্ষই আদালতত জমা দিছে সেই তালিকাৰ ক্ৰমিক নম্বৰ আৰু ঘৰৰ নম্বৰৰ লগত মই অনা ভোটাৰ তালিকাৰ মিল নাই।
What about the village?
Yes, Lordship. Here মই আজি নিৰ্বাচনী বিষয়া নলবাৰী আদেশ মৰ্মে তেওঁৰ হৈ আদালতত সাক্ষী দিবলৈ আহিছো। চমন উল্লেখ কৰা মতে 1966 চনৰ 61 নং হাজো সমষ্টিৰ পুৰাণ চাপৰাপাৰা গাঁৱৰ ভোটাৰ তালিকা লগত আনিছো। 1970 চনৰ 54 নং চেঙা বিধানসভা সমষ্টিৰ গাঁৱৰ ভোটাৰ তালিকা আমাৰ অফিচত মজুত নাই বাবে আনিব নোৱাৰিলো। 1966 চনৰ 61 হাজো বিধানসভা সমষ্টিৰ অন্তৰ্গত পুৰাণ চাপৰাপাৰা গাঁৱৰ ক্ৰমিক নং 73 ঘৰৰ নং 25 খণ্ড নং 24 কত হুছেইন আলী পিতা কবেজ বয়স 35 নাম থকা দেখা যায়। He says that 1966 voter list is genuine, Lordship. যোৱা 4/5/2016 তাৰিখে চমনত যদিও 54 নং বিধানসভা সমষ্টিৰ কালাৰছৰ দ্বিতীয় খণ্ড গাঁৱৰ ভোটাৰ তালিকা আনিবলৈ কোৱা হৈছিল মই কালাৰ্ছৰ প্ৰথম খণ্ড গাঁৱৰহে ভোটাৰ তালিকা লগত আনিছিলো। কালাৰ্ছৰ দ্বিতীয় খণ্ড গাঁৱৰ 1970 চনৰ ভোটাৰ তালিকা আমাৰ অফিচত মজুত নাই। কালাৰ্ছৰ প্ৰথম খণ্ড গাঁৱৰ ভোটাৰ তালিকা চোৱাৰ বাবে যোৱা 4-5-2000 তাৰিখে হুছেইন আলী পিতা কবেজৰ নামটো অপৰপক্ষই আদালতত দাখিল কৰা ক্ৰমিক নম্বৰ আৰু ঘৰৰ নম্বৰৰ লগত মিল নাছিল। Then it was again examined, Lordship, in under that Lordship. On that date he stated that Lordship, মই নিৰ্বাচনী বিষয়া নলবাৰীৰ অথৰাইজ ব্যক্তি হিচাপে আজি এই গোচৰত সাক্ষী দিবলৈ আহিছো। আদালতৰ নিৰ্দেশ মৰ্মে 1970 চনৰ 54 নং টেঙা সমষ্টিৰ কালাৰ্ছৰ আৰু 1985 চনৰ 60 নং বৰক্ষেত্ৰী সমষ্টিৰ হাপকাটা গাঁৱৰ ভোটাৰ তালিকা লগত আনিছো। 1989 চনৰ ভোটাৰ তালিকা অফিচত এভেইলেবল নাই। 1970 চনৰ আৰু 1985 চনৰ যি ভোটাৰ তালিকা অপৰপক্ষই আদালতত জমা দিছে সেই তালিকাৰ ক্ৰমিক নম্বৰ আৰু ঘৰৰ নম্বৰৰ লগত মই অনা ভোটাৰ তালিকাৰ মিল নাই। মোৰ ক'বলগীয়া ইমানেই। কালাৰ্ছৰ ভিলে
Which was submitted at the time of.
So dissimilarity in the voter list.
Dissimilar, yes, Lordship.
Then
Again, Lordship, although proceeding exhibited Lordship one Gaubra certificate Lordship,
exhibit
Lordship. Exhibit 4 Lordship. But then Gaubra did not come before the tribunal to depose him. And another Gaubra Lordship, this certificate was not exhibited Lordship, gave evidence.
exhibit,
This was not exhibited Lordship, this certificate.
so
Only placed before the
Gaura from which village?
Gaubura, one is Duinong Kaplabari, Janto Methi. It to exhibit one. Gaubra certificates are not exhibited Lordship.
Okay,
And it was not proved Lordship.
exhibit 4 not proved.
Not proved Lordship. It was not exhibited Lordship. One Janto Methi has certified that Fulmala Begum, wife of only saying that he is the wife of Jinnat Ali Ahmed of village Kaplabari.
Only to that extent he proved.
Yes, Lordship. Then another Gaubra Lordship, Habibur Rahman, he deposed before the tribunal Lordship.
DW,
DW 4 Lordship.
Habibur Rahman.
Yes, Lordship. He in his certificate, he certified that Hajo Moza Akandi, Muhammad Fulmala Begum, wife of Nur Hussain Ali, is a permanent resident of village Akandi, post office, so PS Hajo, district Tamrabasam. And Lordship, what evidence he has given, Lordship, I want to read that statement, Lordship. OPW 4 Lordship. Honor. ফুলমালা বেগমক এখন প্ৰমাণপত্ৰ দিয়াটো সঁচা। ফুলমালাক মই জন্মৰ পৰাই চিনি পাওঁ। ফুলমালাৰ দেউতাৰ নাম হুছেইন আলী। তেওঁৰ ঘৰ একাদি গাঁৱত। হুছেইন আলীক মই ভালদৰে চিনি পাইছিলোঁ। মই কোঁৱৰপুৰ, হিৰাজিনী আৰু একাদি গাঁৱৰ গাঁওবুঢ়া। হুছেইন আলীৰ দেউতাকৰ নাম কবেজ আলী। মই কবেজ আলীক দেখা নাই। ফুলমালা বেগমৰ বিয়া 2000 চনৰ জিন্নাত আলী পিতা ৰহিম আলীৰ লগত হোৱাটো মই জানো। প্ৰমাণপত্ৰখনত এখন ফৰ্মেট হোৱা হেতুকে মই ফুলমালা বেগমক সেইখন ফৰ্মেটত একাধিক গাঁৱৰ স্থায়ী বাসিন্দা বুলি লিখি দিছো। বৰ্তমান ফুলমালা বেগমক একাধিক গাঁৱত নাথাকে। বিয়াৰ পিছৰ পৰা ফুলমালা স্বামীৰ ঘৰত থাকে। ক্ৰছ পাৰ্ট লৰ্ডশ্বিপ। প্ৰমাণপত্ৰখন আনিবলৈ ফুলমালা বেগমৰ ওচৰত ফুলমালা মোৰ ওচৰত নিজে গৈছিল। তেওঁৰ বিদেশী ন্যায়াধীকৰণত কেছ হোৱা বাবে দেউতাকৰ ঠিকনাত প্ৰমাণপত্ৰ লাগে বুলি কোৱাত প্ৰমাণপত্ৰখন দিছিলো। ফুলমালা বেগম একাধিক গাঁৱৰ স্থায়ী বাসিন্দা বুলি ভুলতে দিয়া গৈছে। ফুলমালাৰ বিয়াত মই উপস্থিত নাছিলো। মোৰ পৰা প্ৰমাণপত্ৰ আনিবলৈ যাওঁতে ফুলমালাই জিন্নত আলীৰ কাগজ পত্ৰ লৈ গৈছিল। That is জিন্নত আলী her husband, yes lordship। আৰু তাৰ ওপৰত ভিত্তি কৰি তেওঁ কোৱা মতে প্ৰমাণপত্ৰখন লিখি দিছিলো। Yes, lordship। And lordship, procedure relies on the photocopies of voter list of 1970, 1985, 1989, 2005 and 2012, lordship।
1985, 1989,
Yes, lordship। 89 and 1970 are not available।
1970, 1985, 1989,
2005 and 2012,
all are photocopy.
all are photocopies, lordship।
Relating to which village?
1970 is color, sir। 1985 is lordship। 2005 is কাপলাবাৰী, 2 নং কাপলাবাৰী আৰু 3 নং বৰটোলা। And
What about 85, 89,
1970 is color, sir।
Hmm.
Then
85,
when lordship 85, it is 1985 of village Tapkata। Then lordship 1989 also Tapkata। These are the voter list, 2012 voter list I could not find, lordship। Although it was reflected in the order also, 2012.
Okay, look into it.
Yes, yes, sir।
Come back.
Lord, item 4 can be accommodated only for 2 days, my lord. Second of I have come.
item,
4. Hearing it. only for the thing.
Let the matter, you will pass. Order, don't
Yeah. Apply.
don't- Tuesday in that case. Yes. Dharma. Yes, Mr. Sharma, please carry on. Just tell us one thing, whether the proceeding in the written statement mentioned that our father was in different places. Okay, we'll get it. So according to you, there are discrepancies and the contradictions in the voter list. WBC number. This is not reported, I believe. Citation. You don't have to give us the WBC number, give us the site. Reported in just a minute. Just a minute. Yes. Yes. Hmm. Sixteen point. Okay. Hmm. Which one, exhibit 4? Exhibit, which one? Which exhibit? Okay. The comptroller statement. Three eight zero seven. Which para? Yes. 4020. One is 2018 one GLT. One GLT. Vijay Dice, which paragraph? The other two citations, WBC 1900 2019 and 4020 2017. three GLT. 4 or 3? 2017, 3 GLT or 4 GLT? 346. Yes. Okay. What else? Para 25. Please. Two thousand 4 GLR 295. 2017, 3 GLR. Okay. Give us the relevant paragraph. Verma. Coconut mart. ফুলিবই নোৱাৰো ফুলিব নোৱাৰো মই সেইটো সেইটো আছে। 80 মাতি দিওঁ দেখাব পাৰিম। Anything else? Two thousand 17 5 GLR. Para 5. 2017 2 GLT. Hmm. So, in a nutshell, your case is that though the proceeding failed to establish her case as required under section 9 of the Foreigners Act, the tribunal, relying on the evidence adduced by the petitioner which was not reliable or discrepancy or there are contradiction, considered the case of the proceeding and declared her to be in that much. Yes, Mr. Mahmood. Pass on the record, please, Mr. Sharma.
Was solemnized on 10/8/2000 with Jinnat Ali Ahmed of village number 2 Kaplabari, and since then she is living with her husband. Her father's name recorded in the voter list of 1966 as Hussain Ali, son of Kabej in village Puran Chaprapara under 61 number Hajo LSC, White part number 24 Ko, house number 25, serial number 76. Exhibit 2. So 1966 voter list she has produced in original. But so far the 70 voter list she has produced the photocopy. Now, a number of documents are not necessary. If one document is found genuine, that is enough. So 66 voter list has been proved in original. And 70 voter list, my lord.
Mr. Mahmood, this Yes, next.
My lord. Now, exhibit 2 is the photocopy of the voter list, which is proved in original. Her father's name also enlisted in the voter list of the year 1978. Hussein Ali, son of Kabez of village Kalachor, PS Nalbari, under 54 number Senga LSC, White Part number 25, house number so and so. Her father's name also enlisted in the voter list of 1997 as Hussein Ali, son of Kabez of village Akadi, under number so and so. So Kabadi and Kalarchar, these are adjacent villages, my lord. It is judicial notice I am drawing. It is within Nalbari district, adjacent villages, very nearby villages, and that is also near the bank of river Brahmaputra. Then Akadi, a police station, part 52, house number 139, serial number 398. Exhibit 3 is the photocopy of the voter list, which is proved in original. So, 1997 voter list, that is proved in original. Proceeding further deposed that her name enlisted in the voter list of the year 2010 as Fulmala Begum, White Part number so and so, house number so and so, village number 2, Kaplabari. Exhibit 4 is the photocopy of the said voter list, which is proved in original. So this is the voter list of her husband, with her husband. Now, my learned friend has said one thing, that photocopy is not admissible. Photocopy, my lord, photocopy, our High Court has also, at post I have not brought the judgment. Photocopy has also got value. And here is more valuable, because it is not raised object, it is not objected. When the 1970 voter list was produced, my lord, the learned government leader was there, but he did not raise any objection. And it is settled position of law, any objection regarding any document should be at the trial stage. To that extent, I will submit citation. So, at that time, they were keeping mum, and High Court they are saying they cannot say, it is not permissible under law. Because had it been raised at that time, the party would have got a chance to explain. But that is the law, my lord. Had it had been objected at that time, the party would have got a chance. Yes, I have produced photocopy because of this and that reason. But at that time, no objection was there. So it is presumed as accepted. Because she got no chance of explanation. During cross-examination, proceeded deposed that residence of her father is in Akadi village under Hajar police station. Her father's name is Hussein Ali. He is expired. Her husband's name is Jinnat Ali Ahmed. Now she is residing in number 2, Kaplabari. Name of her father-in-law is Rahimuddin Akan. She is casting vote since 2010 from Borkhetri constituency. Name of village headman of number 2, Kaplabari village is Jayanta Medhi. She does not know that her father-in-law's name has been wrongly recorded in the voter list. So, these are irrelevant questions. These are irrelevant questions. Father-in-law, I will get my citizenship through my father. So, father-in-law's name is wrong or right. This cannot be raised, madam. And if it is raised, but that is not accepted in law. A person gets citizenship through father or mother. As per the Assam section 6A, either of the parents. Normally, our tribunals follow this fathers, but mother is also acceptable. If the mother's name is also included in any of the voter list of 25th March 1971, that is enough. So here 66 is original method. So there is some discrepancy wrong in the name of father-in-law. It is immaterial. And she does not know that her father-in-law's name has been wrongly recorded in voter list. She has not submitted any application for correction of the name. So it does not, why I will file petition to correct the name of my father-in-law. So it is totally immaterial. Name of our mother-in-law enlisted in the voter list. Her name is Moejan. She has not submitted any certificate from the village headman of her father's village. She has submitted NRC document. Now, Lordship, one thing Lordship should be always see that everywhere her father's name is Hussain Ali. Every person A to Z, every person, the village headman, one Habibur Rahman, election officer, she herself, and the headmaster, superintendent of that school where she read, they all are saying that her father's name is Hussain Ali. There is no rebuttal on the part of the other side. On examination by the court proceeding, deposed that she was reading up to class 9 at Kanbari High Madrasa. Name of her mother is Jahira Khatun. Her father's name is Hussain Ali. About 3 years ago, he expired. Her grandfather's name is Kabes. Name of her elder brothers are Jainal Ali and Ainal Haq. She has submitted photostat copies of voter list of the year 1970, 85, 89, 2005, 2012. She has not obtained certified copies of the same. Neither police personnel went to her house for investigation nor took her statement. Sarvan Begum and Bulbuli had given false statement before the police. Here, my lord, it is seen that always, continuously, her name is appearing in different voter lists. Continuously, her presence in the soil of India or Assam is present continuously. And over and above, she has also raised a serious doubt about the investigation that this Saravan, Begum or Bulbuli, these are imaginary names. They never said anything before the police officer when the police officer went for inquiry. OPW to Ramani Sharma, authorized person of election officer, Dalbari, deposed that name of Hussain Ali, son of Kabej, appeared in the voter list of 1966 and the 61 number Hazul Assembly Constituency of Village, Puran, Chaprapara, white serial number so-and-so, house number so-and-so, as 35 years. OPW further voter list of the year 1970 of Kalarshore, second part is not available in their office. So that may be one of the reason, my lord. That may be one of the reason that voter list of 1970 certified copy, my lord, she could not produce because that list is even not available in the election office. But somehow she got the Xerox copy because a copy of the voter list are kept at the house of the Gaura. So normally people take photocopies from there. But here, as in the office, 1970 voter lists are not in the election office, so necessarily certificate copy cannot be obtained. It is natural. OPW 3 name Muhammad Asimuddin Ahmed, in charge superintendent of Kanbari High Madrasa, deposed that he is working as in charge superintendent of Kanbari High Madrasa. In the year 1984, he was appointed as assistant teacher of the said madrasa. Madrasa was provincialized in the year 1984 to 2002 and attendance register for the year 1999. As per the admission register of the year 1998, Fulmala Begum had taken admission in their madrasa in class 8. Her admission serial number is 805. As per admission register, her date of birth is 1783. It is seen that Fulmala Begum was reading in their madrasa up to class 9. As per the daily attendance register, she was present at class 9. The certificate issued in her favor was signed by earlier superintendent. He identified the signature. He is confirmed that the signature appeared in the certificate is his signature. Name of the earlier superintendent was Mujibur Rahman. He retired in the month of February 2015. Cross-examination was declined by learned assistant government pleader. Here also a very important thing is there. The superintendent is producing all the admission registers and the records from the year 1984 to 2002. Here her name is there, and she has also clearly said that my date of birth is 1783 as per school admission register. My lord. She said as per she is saying that my date of birth is 1783 as per school admission register, because she has no date of birth certificate. So her statement corroborating the documentary evidence of the school. And one important thing is this, my lord. This matter was not opposed by the learned pleader, learned opposite party pleader, that he declined. That means what? Everything is admitted. So very necessary witness, man. The superintendent brought registers 2002 to 1984 to 2002, and in that explanation, her name was there. He has also said she was schooling. She was coming to school. It is personally knowledge, and earlier superintendent signed the certificate. But at the time when this present superintendent in charge adduced evidence, he retired. So he came and deposed that, yes, this is the certificate which my predecessor has issued. He knows his signature. So this is the provision of law. Because one officer may die, but document may be there. So document, if someone says that I know the signature of so-and-so person, that is enough. Unless it is rebutted with proper reasoning. Only rebuttal is not for the sake of rebuttal. Rebuttal must be reasonable. Here there is no rebuttal. On over and above, it is necessary. Now, Lordship would say para 7, my lord. OPW 4, one thing, sorry, my lord. OPW 4, however, Lordship may kindly see with page 12, para is not given, it a middle portion. OPW 4, Muhammad Habibur Rahman, village headman, deposed that it is true that he has issued a certificate in favor of Fulmala Begum. He knows Fulmala since her birth. Name of Fulmala's father is Hussain Ali. His residence is at Akadi village. He knew Hussain Ali. He is the village headman of Koarpur, Hira Jeni, and Akadi village. Akadi is coming here. 3 villages headman he is, and out of these 3 villages, Akadi is also one village where the proceeding is deeply connected. Father's name, he knows the marriage of Fulmala was solemnized with Jinnat Ali, son of Rahim Ali. Now Fulmala is not residing at village Akadi. After her marriage, she is residing in her husband's house. During cross-examination, OPW4 deposed that Fulmala personally went to his house to bring the certificate. Due to mistake, he has written in the certificate that Fulmala is permanently residing in Akadi village. He was not present in the marriage ceremony of Fulmala. So, my lord, he is clearly saying that Fulmala went to my house to collect the certificate, and I issued. But he issued the certificate of resident Akadi, where her parents are living, not husbands. So this mistake has been committed by him, and he has also admitted. But it has no bearing on the citizenship. Bearing is that Fulmala is the person who is residing within her Gauraship area. So that is the thing. And the writing wrongly name of her parents' house instead of husband's house, it has no bearing with the citizenship matter. During the course of argument, learned counsel for the proceeding produced some additional documents. Original copy NRC 1951 of the father of the proceeding issued by in-charge president. This is not actually not accurate, because Jamiatul Ulama has no legal authority to issue. I am not going to that aspect. And over and above, NRC is also not the proof of citizenship. So let us forget about this. We are not taking this matter seriously, my lord. Now, Lordship, may kindly see page 13. Page 13. After I'm reading from the top. Photocopy of cell deed number so-and-so dated 2385 in the name of father of the proceeding and certified copies of voter list of the year 2005 and 2008, wherein name of proceeding appeared as voter in village number 2, Kaplavari, under 60 number Borkheti LSC, and submits that the name Hussein Ali, father of the proceeding, recorded in the NRC 1951. Voter list of the year 1966 and 1970 as voter under 54 number Senga LSC. Being a citizen of India, Learned Council further submitted that proceeding was born and brought up at village Akandi under Hajar police station, and her date of birth is 1783. So these are the repeating these submissions are by Learned Council, that on the basis of so-and-so documents and on the basis of so-and-so depositions, she is an Indian citizen. In that manner, he submitted. Now, Lordship, here was the learned government period said. On the other hand, learned assistant government period submit that there is some discrepancy in the name of the father and grandfather of the proceeding. In some documents, father's name is name of the proceeding recorded Hussein Ali, and in some other documents as Hussein Ali, and some other documents as Hussein Mondol. Similarly, in some documents, father's name is Hussein Ali, shown as Kabez. No, Kabez is the grandfather. In some documents as Kabez Ali, my lord, here, I am surprised. On the 7th, I went to cast my vote, and my name was there as the female. My name is against my name, female, it is written. So my own experience, I am telling. This year at TC High School, Higher Secondary School, I said, how I have become female, I don't know. But it is not only I, several other persons' name was also like that. Male is female, female is male. So these are common mistakes. Judicial notices required to be drawn up. If in the long run a Bangladeshi case started against me, I will be in trouble because if you are a female, how you have to see that you are a male here. So these are the situation.
You have not taken steps when the list was published, draft voter list was published. in
Yes,
December, there
actually,
was
I did
time
not
was
take
when
any. That is correct.
the
Not
election
file any
commission has
petition.
notified throughout India.
So
It is everything is just click. You get in your mobile, you get in your.
now, Lordship, yes, I understand that I should have filed petition for correction because only that time, before 2 or 3 days, I let me collect my voter, then I found this. So, my lord, these are the things here. The things are, but here most important thing is this: there is mistake in drafting WS as well as evidence. But the evidence of Habibur Rahman, evidence of this election officer, but the election officer's names that the serial number does not tally house number, for that she is not responsible because she has produced the certified copy. Supreme Court, our High Court also said that the certified copy has been produced by someone. Now that copy does not tally with the other copy, but you have not challenged the authenticity.
Just a yeah. Yes, please.
Madam, regarding issue certificate matter, I have, I am reading, Lordship, 2009, 12 SCC, 454, para 21, 22. School certificate is admissible even without examining the headmaster or the issuing authority. So here, the superintendent came and deposed his witnesses. And there is in regarding certificate, my learned friend of the other side declined to any cross-examination. So this is regarding school certificate. So this is apex court's decision. What my learned friends submitted, basically of High Court. And definitely the decision of Honorable High Courts are also most valuable. But when there is a decision of the apex court, the letter will prevail. That is my humble prayer. Regarding Gaura certificate, Lordship, I am submitting one thing. A Gaura, I am reading the operative portion. A Gaura would have certain knowledge about the affairs of the village and the villagers. The Gaura had categorically stated that he knew the proceedee and that he also knew that proceedee is a resident of the locality. He also categorically stated that he knew the father of the proceedee and that he died. He stated that he knew the father of the proceedee as a resident of his locality for the last 40-50 years. He also stated that the proceedee had been married to Kolohovanga village. So here, Gaura is the lowest category of civil officer. The Gaura has a civil, Gaura is a civil authority. Even police chief goes to village, they take the assistance of Gaura. So he knows better. Here Gaura is saying, yes, I have issued this certificate, I know her. She has been married to so-and-so, she is the daughter of so-and-so. So this is a reported case, my lord. I am submitting reported case. Lordship would see order dated 28/9/22. Passed in WBC number 5739, para 18.
5739 of which year?
5739 of 2018. 2018, para 3637. Here, Gauri Goswami Rai versus the Union of India. Here, Lordship, it is said by our Honorable High Court that Gaura have certain knowledge about the affairs of the village. Here, Gaura has given the certificate, also testified. And her testimonies, why should be disbelieved? What was the reason? Gaura is their officer, not our officer. Their officer. So that Lordship would kindly consider. So far regarding interpretation of document, my lord, I am submitting. 2001, 2 SCC, 721, para 23, last part. Interpretation of statutes, basic rules, literal and strict construction ought to be scrupulously avoided if it inevitably creates various anomalies and finally defeats the ends of justice. The interpretation should be meaningful and purposeful and also to advance the cause of justice. So here, my lord, here is a foreigner's case. The burden of proof up to what extent? That I am coming to that aspect. Up to what extent is necessary, I am coming to that aspect, my lord. Then Burden of proof, Lordship may kindly see. Uh, Two 2021 2 GLT 1021 para 15 Moharuddin Ali versus Union of India. Burden of proof in FT cases are preponderance of probabilities. So the legislature has enacted section 9 of the Foreigners Act. Burden of proof lies upon the proceeding. But it is interpreted by the constitutional courts. That is the High Court and Supreme Court. So our High Court is saying burden of proof in FT cases are preponderance of probabilities. It is 2021, just 2 or 3 years back. My learned friend has shown all citations mainly. Of course, alls are also gold, subject to not varied by the apex court. So burden of proof, and then Lordship, another citation on this aspect, 2001 4 SCC 375 para 19 my lord.
2001 4 SCC
4 SCC 375 para 19. Here, my lord, the Honorable Apex Court says presumption under section 106 of Evidence Act is not intended to relieve the prosecution of its burden to prove guilt of the accused beyond reasonable doubt. Here, 106 and section 9 are same. 106 of Evidence Act and section 9 of Foreigners Act are same. So it does not relieve the prosecution that they are the burden is shifted. When I have produced prima facie that I am a citizen of India, burden is shifted to them. Now honors is shifted to them. They have not discharged their honors, rather they have declined to cross-examine. So that is another aspect. Now Lordship may say regarding the value of electoral roll, my lord. Sorry, before that, my lord, I was showing one public document 22. Here, Lordship, 2004, 12 SCC, 36, 2004, 12 SCC, 360, para 11 and 12. Here, my lord, any objection regarding a document must be at trial stage, not thereafter. My learned friend has come here with so many objections, but at the trial stage, they were keeping silence. So, my lord, Honorable Supreme Court says it should be raised at the earliest, at the trial stage, so that if the purpose behind object is this, so that the other party can explain. But here, now my learned friend is raising objection. The proceeding is not here. How she or she can convince the honorable courts? So that has to be raised at the earliest stage. And another judgment, my lord, this is 1981, 1 SCC 560, para 3. Here, public document is admissible in evidence without examining its authors. Suppose I have passed matriculation examination, my lord. Admit card is issued by the controller of examination. Now it is not necessary that controller should come. I may produce it, I may exhibit it, that is public duty. Now it is their duty, they shall have to prove, though no, it is false. So what I have said, they kept mem regarding discrepancies of names and ages, Lordship. Already, I think learned tribunal has raised two questions here is raised. That is Abdul Mutali's case, and another case perhaps not said, that is Sirajul Haq. So these are not serious. Abdul Mutali's case said that names, discriminating names, ages, and shifting of residence The similar view is also expressed by the Honorable Supreme Court in Siraj Locke's case. That is also reported case. I have also that case, but at present, so that is the thing. Then Lordship may kindly see, my last citation would be here. Here, one thing, my lord, is this, that electoral rolls, voter list is a public document and may be accepted as evidence without examining its author. So here, Lordship, I have already said that some voter list of 1966 original, 70 is not found in office. When it is not in office, party cannot produce it. Only Xerox copy, that is the reason. The other things, he has also produced some original, some Xerox copies. But those are not raised any objection. So those are have been accepted by the learned tribunal without raising any objection from the other side. So in this regard, Lordship is aware, section 21 of the IPC. Section 21 of IPC says there are 14 categories of documents, my lord. 15 categories of documents, public documents, which have been accepted as public documents. So those 15 categories of documents, section 21 of the IPC, that Lordship may kindly go through it. Section 21 IPC, there are the documents which are public documents, and among those documents, I have proved several documents. Proved, not only submitted, it is proved in view of section 67 of the Evidence Act, IPC section 21. So I have not only proved, and let's see, section 21 of IPC, which are public document. IPC, okay. Lordship has said,
It's not public document. 21 relates to.
no, public servant, but public servant, whenever issued any document, that is public document. There are who are public servants, it is also written. Public documents means which document issued by public servant, and that public servant is answerable to government by law. That is why the private schools document are not accepted, because they are not answerable to authority. Here, Lordship would say, the word public servant denote a person falling under any of the section here and above. Every commissioner, commissioned officer in the military, naval, or every judge, including any person empowered by law to discharge, whether by himself or as a member of any body, every officer of the court, I'm saying every jury, a jury assessor or a member, every arbitrator, every person who holds any office by virtue of which he is empowered to place or keep any person in confinement, every officer of government. So every officer whose duty is as such officer to take, receive, keep, and expend the property on behalf of government. So my lord would kindly see here that these are the public officers who are answerable to government, and who are answerable to government, they are public officer, and what document they have issued, those are public documents. And section 74 also, Evidence Act is also like that. Section 75, Lordship, you see, the following documents are public documents forming the acts or records of acts of the foreign authority, Lordship, of official bodies and tribunals, and public officers, legislative, judicial, and executive. So it is within executive, my lord. Or any part of India or a Commonwealth or of a foreign country, public records kept in any state or private documents. So they are keeping the election officer is keeping the this voter list. So he is keeping those records. Then also could kindly see, Sirajul Haq, I have found it, my lord. No person become a foreigner for anomalies in names and address or shifting or residence. It is lordship may kindly note down. 2015. No, it is 15 Abdul Botali. It is my lord 2019, 5 SCC 534. Para 2 to 5, Sirajul Haq, Justice of Assam, for anomalies of names, ages, and shifting of residence does not make a person foreigner. But here, my lord, I have at first I have admitted there should have been some explanation, my lord. That my father originally there was resident of Akandi, then shifted to Kaplavari. So there should have some explanation should have been given, but that is not given. What is not given, I cannot make it now done. So that is the mistake committed by the learned counsel committee who conducted the case. So if your lordship is on that seriously, that there is no explanation, because so many other things are in my favor. Gauras, superintendent, public documents. If your lordship is on that, it will at best be remanded, at best. But my lord, it is settled position of law, if there is two views possible, the view favorable to the accused, here we may say proceedings should be accepted. So though there are some anomalies, some lacunas, and another view is possible, but that is not a ground to interfere.
Mr. Mahmood, if the order is, if we come to a conclusion that this order is bad, automatically it will go back to the tribunal for fresh decision. Nothing
If your lordship so thinks, I do not say,
we are
that
not-
is my last submission, because explanation is not given. I also, being a student of law, what I know that there should have been some explanation, but that is not given. Only say that my father's name is listed in voter list of so-and-so village in the so-and-so year, and Omuk village so-and-so year. So in that manner, so many things are there. But thereafter he shifted due to erosion of river Brahmaputra, he shifted to this village. Thereafter again due to erosion, my father shifted to village Kaplavari. So this should have been brought on record. So in that view, my lord, I am very fairly submitting that if your lordship take this view seriously, then it may be remanded. But that is not my prayer. That is the last.
Exactly.
My lord, I have not given your lordship this book. I have provided your lordship, but your lordship has I have provided this book. No, I have copy understood. I have written this book, so so that is my humble prayer, my lord. The writ petition filed by the state government should be rejected. Therefore, person against this person mighty state has coming. It is otherwise also pathetic. Obliged, man.
My lord, my senior friend will want to give the reply.
Yes, Mr. Pai, what do you?
My lord, as your lordship has seen the entire scenario, my lord, it is admitted position, my lord, the tribunal, before the tribunal, my lord, only the exhibit documents prior to 1971 was the 66 voter list. Other 70 voter list was not exhibited. Though my learned friend, senior friend is saying, my lord, it should have been objected on the very first day, but it was not exhibited at all. How the tribunal has considered the documents, it's very surprising, my lord. At the time of argument, it was submitted and it was considered. So it is, in fact, the tribunal has considered an inadmissible documents and which was not legally submitted before the tribunal. So those documents cannot be accepted, my lord, and those should not have been considered. That was the first point. The second thing, my lord, my learned senior friend is arguing one point that my lord, birth certificate, the school certificate was exhibited, and as the school certificate has reveals that says the daughter of the Hussain Ali, so it should have been accepted. That is the only point. Because from the entire documents, only one document is linking the father is the school certificate. Now, the school certificate, whether a school certificate can be accepted. First of all, the school certificate, the village name is different, and the father existence of father is in a different village. Existence of father in 1966, because if we ignore all other documents, because those documents were not exhibited, so the learned AGP did not get the opportunity to cross-examine those documents. So only valid document was 1966 voter list. So 66 voter list, it says he was the resident of Puran Sapra. And the school certificate says the daughter of Hussain Ali of village Sapkata. So these are totally two different villages. First of all, that has to be amendment. That was not considered by the tribunal. That should have been considered. That is the evidence in record. But without considering that evidence, he cannot pass that opinion. So it is, my lord. And secondly, my lord, the Viratmal Singhvi, 1988 Supreme Court SCC, my lord, Supply SCC 604. 1988 Supplementary SCC 604, my lord. Para 14, my lord, in that case. Para 14. Last part of the para 14, my lord. It is in page 618. It has said, my lord, in the present case, my lord, the author of the certificate was not before the tribunal. It was another superintendent of a school who came before the tribunal, who, my lord, giving the evidence. What the Apex Court has said on with regard to the date of birth of the mother and of the birth certificate of the school certificate, my lord. Here, my lord, I'm just reading one para of that, my lord. The testimony of Anantaram Sharma and Kailash Chandra Taparia merely proved the documents, but the contents of those documents were not proved. Thus, the date of birth mentioned in the scholar's register has no evidentiary value unless the person who made the entry or who gave the date of birth is examined. So, when the entry contained in the admission form or in the scholar's register must be shown to be made on the basis of information given by the parents or a person having a special knowledge about the date of birth or the person concerned. So, my lord, this judgment has taken.
You are reading which judgment?
My lord, this Viratmal Singhvi 19.
Oh, that's true.
Yes. Para 14, my lord. page 618, my lord, last part. If the entry of the scholar's register regarding the date of birth is made on the basis of information given by the parents, the entry would have be eventually value. But if it is given by a stranger or by someone else who had no special means of knowledge of the date of birth, such an entry will have no evidentiary value. Merely because the documents exhibit 8, 9, 10, 11, and 12 were proved, it does not mean that the contents of the documents were also proved. Mere proof of the documents exhibit 8, 9, and 10, 11, and 12 would not amount to proof of all the contents of the correctness of the date of birth stated in the document. Since the root of the fact, well, this is the fact, well, here, to ascertain the truthfulness of the contents of the documents of the date of birth of the school certificate, first person is to examine is the parent who has given the information that my son or my daughter has been admitted in this school and her date of birth is so and so. He is the first person who can be examined and who can give the truthfulness of the contents of that particular fact. Second is the person who has entered that fact in the register. Suppose the headmaster, if the headmaster entered the facts in that particular register, that headmaster should be examined. Only then only the contents of both, either of what, the contents of that particular documents or particular facts will be proved. This is the position laid down here in this judgment. And this judgment has been relied on by this honorable court.
Reopen Korea to the joint one. Reopen Korea side.
So that point was accepted in numbers of cases in foreigners issues also, because your lordship may kindly will consider, this is not a simple criminal case or civil case. This is a case of the state concerned, because the security of the state is concerned. The Sarbananda Sonowal has all the judgments of the apex court, Sarbananda Sonowal letter and this honorable court in SRS Chaudhary case also concerned that the security of the state is concerned. So here there are similar, why this tribunal has come up. Otherwise, in all other states, normal court, normal police is taking the action. This tribunal is set up in India, Assam, because people who are migrating from East Pakistan, they are similar, they have some similarities with the people who are living in the state of Assam. So it is very difficult for the state to find out who is foreigner, who is Indian. So in this case, my lord, we have to examine all the documents, everything in very minor. By not doing that, my lord, tribunal has actually, the foreigners tribunal, learned tribunal has failed to discharge its original duty for which purpose it was set up. In Anima Das case, my lord, 2019 3 GNT 1 to 122. (2019) 3 GLT 122. Para 16, in fact, from para 15 onwards, 14 onwards, 14 to 18, the Virat Bal Singhvi has been discussed, and it is settled that the certificate is not enough, and the school record is also not enough. It has to be proved by the person who has entered it or who has given the information to the school authority. So this is on birth certificate, a school certificate. Which regarding rebut, before going to the case, your lordship may kindly see burden of proof never shift to the states, my lord. Para 26 of the Sobananda Sonal, I always used to read that one, para 26 of the Sobananda Sonal. But I want to read once again, my lord, because it is very important. It is the basic of the, my lord, basic of the all the foreigners cases of foreigners, para 26 of the Sobananda Sonal. Because the burden is given to the tribunal, my lord, proceeding to prove that he is not a foreigner. There is a good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country, because this principle has been accepted all over the world, not only in India. So in the countries, all over India, world, these countries are taking this principle. In order to establish one's citizenship, normally he may be required to give evidence of what evidences are necessary to be given by the proceeding to establish his citizenship. This is clearly given. First of all, his date of birth, which is very compulsory. His date of birth. Second is place of birth. Third, name of his parents. Fourth, the place of birth of and citizenship of parents. Sometimes the place of birth of grandparents may also be relevant, like under section 61AD of the Citizenship Act. So these are the facts which has to be established by the proceeding in the tribunal. Only these are the facts. And all these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. After he has given after he has given evidence on these points, the state authority can verify the facts and can give lead evidence if necessary.
In rebuttal if necessary.
In rebuttal if necessary. So it is the duty of the proceeding to establish all these facts. After he has given evidence, then only if necessary, the state may rebut it. It is not that the state is to rebut each and every case. So all these facts has to be established first by the proceeding by bringing cogent, reliable, and admissible evidence. Once it is established, or once the proceeding bring the cogent, reliable, and admissible evidence, then only state may go for rebuttal. That is the point, my lord. And this is settled position. In other cases also, the Honorable Apex Court has said, my lord, in Ghaus Mohammed case, in 1961 itself, my lord, the Constitution bench, here in 1961, SC 1526, my lord. Here in 1961, SC 1526. Para 6, my lord, it is said. Section 9 of the Act is that one that is relevant. The section so far is material in this terms. If any section 9 is quoted, my lord, if any case not falling under section 8, any question arises with reference to this act or any other matter or direction given thereunder, whether any person is or is not a foreigner, the onus of proving that such person is not a foreigner shall, notwithstanding anything contained in the Evidence Act 1872, lie upon such person. This statute is clear. Statute itself is clear. Then it is, when Apex Court says, it is quite clear that this section applies to present case, and the onus of showing that he is not a foreigner was upon the respondent. So it is the always duty of the respondent proceeding to prove that he is not a foreigner. And this point was taken, my lord, in one case No, this is also an writ petition filed by the state against declaration of a person to be Indian by considering some immaterial facts. This is WPC 2641 of 2017.
2641.
Yes, 2641 of 2017.
Okay.
2641 of 2017, the state of Assam and others versus Pohab Ali. Here, one point was discussed in para 16, my lord.
There are 16.
Yes. Para 16, may I read it? On the other hand, from the impugned order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, tribunal ensured the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench of this court in the state of Assam versus Muslim Mandal, reported on so and so. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. This burden never shifts. The burden has to be discharged by the proceedee by adducing which are admissible. So the admission, evidence must be admissible, which must be proved, then it should be proved, and which must have relevance to the fact in issue. So these three things are to be done. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged this burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance. So this is exactly the proposition laid down in para 26 of this order. But this is reported, 2018 4 GLT 360. The same 2018 4 GLT 360. The learned tribunal has relied on the Abdul Matuli case, which was later on by another judgment of this honorable court has clarified, my lord. That is 2018 1 GLT 372. The last page 8 of that judgment, my lord. Third last paragraph. And it is said, my lord. Two things are there, my lord. First of all, the Abdul Matuli has been clarified. Secondly, my lord, the petition here said the voter list, the 1966 voter list, if it is, my learned senior friend is arguing that, my lord, the discrepancies is not us. It is always there in the voter list. It is committed by the authorities. And so it cannot be, my lord, be taken against the petitioner. So here, these two things are clarified, my lord. Reliance placed in the case of Abdul Matuli versus Abdul Matuli can be of no assistance to the petitioner is in as much as it has already been clarified by this court in previous decision that said decision did not lay down any law and was a decision of confined to the facts and circumstances of the case. Regarding discrepancies in the voter list, which the petitioner contained were not of her creation, being entered into the official election commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. That cannot be done. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. So this point has two effects, my lord. The school certificate, if my lord, senior friend accept, my lord, it has to be accepted in whole. Similarly, the voter list of 1966 has to be accepted as a whole. The village there in 1966, the village may be differ, so it may be ignored, and the village in the school certificate may be differ, so it may be ignored. That cannot be, my lord. It has to be accepted as a whole. If the document is correct, document is correct. If the document is wrong, document is wrong. If he is relying on the documents, he has to rely everything. The village, the malad, the contents, other contents. He cannot say, oh no, names are correct, so it may be accepted. The village is wrong, so it cannot be accepted. That cannot be. And another aspect, malad, above all these things, malad, the election, malad, person who has come from election office, he has clearly said the 1970 voter list, which the petitioner has produced at the time of argument, does not contain the the house number and the serial numbers are not correct. What does it mean? I'm not saying, my lord. What does it mean, my lord? It shows the malafidness of the person concerned, he has not come with clean hand. The procedure has not come with clean hand. So all these facts, all these things, all these points were ignored by the tribunal, and on the basis of some inadmissible documents, inadmissible evidence, he has given his opinion, which is liable to be set aside. I admit, my lord, in certiorari jurisdiction, the power of the honorable court is very limited. But if the tribunal considers inadmissible evidence, it can be, my lord. That is what, my lord, the certiorari jurisdiction is. So that is my humble prayer.
As a matter of reply, well, only 4 or 5 minutes, I would say. First thing, my learned friend said that the person who informed about the date of birth of the proceeding, it is not possible because it was her father and her father is dead. So record itself is enough. So far, my learned friend has said one thing: the burden never shifts. It is against the law laid down by Honorable Supreme Court. That is, my lord, 2006 5 SCC.
2010.
2006 5 SCC 558 para 14, 16, 18 and 19. Here Lordship would say, in terms of section 102 of Evidence Act, the initial onus is on the plaintiff, and if he discharges it, the onus shifts to the defendant. So my learned phrase is not correct. And Lordship is aware, any decision of the Honorable Supreme Court cannot be violated by any authority or any court of India, maybe the highest court of the state. So any decision of the Supreme Court is binding upon all the authorities in India, including the high courts.
Okay.
So My lord, last one, another submission, my lord. My learned friend has said about Sarbananda Sonowal's case. My lord may kindly note down 2006 1 SCC, 2001 SCC 368, para 9 and 11. Here, court should not place reliance on a decision without discussing as to how the factual situation fits in with the factual situation on which reliance is placed. Circumstantial flexibility makes a world of difference. So any decision should be in accordance with the facts and circumstances. So that was the issue that lakhs of foreigners have come on that context, not regarding other matters. Issue was that whether IMDT was legal or constitutional. That was the one issue only. Honorable Supreme Court discussed many things, but the main issue was that whether IMDT Act is constitutional or legal. The Supreme Court said it is not constitutional.
Enough for the day. My sister Thakuria madam is also waiting. We have a second DV. Mr. Z. Sharma, Standing Counsel, Department for the Petitioner State, as well as Mr. Ayman Mahmood, Learned Counsel for the sole respondent. Sole respondent. Also heard Mr. A.K. Goswami, Learned Secretary for the petition. About the order. We'll come back for the second DB.
The hearing. Cases are listed for orders. Whether your lordship would hear or it may be listed for admission hearing or. But an IT made, my lord, I have some prayer.
See, earlier myself with sister heard this matter, and on 2 occasions it was made hard in part,
Yes.
right? And the matters were fixed it for orders hereafter. But somehow and last was listed on 19th of December, just before winter vacation. So direction was issued that to be listed after winter vacation. Then it came just after view vacation. Then it was fixed today. If you want to be able to complete it today,
Not so short.
no, you can do one thing.
Okay.
We're discussing, so if we take these matters from 10-15, whole day or whatever, we'll sit, this bench will sit at first. We can take it on 16th. If somehow the matter is not complete on 16th, then we have another date on 21st. So if you agree, we can fix accordingly on 16th and 20th. But subject to your availability about Mr. Payang and all. 16. But sister will not be available there. Because during the motion days, we don't like to keep these matters.
Can it be on 14, my lord, Tuesday 14? Hearing the dis-
If it is not complete on 14, then what about 16?
16 at 2, my lord, then.
16 at 2.
Yes.
In that case, we'll have it on 15 at 2 o'clock. Then carry over to 16.
Yes.
Just a minute, take yours. Let us inquire into the matter. Because for fixing such bans, has to be approved by Honorable Chief Justice. Because these are on the administrative side order. So let us It's just different. Up to you, like. Who is appearing for 7? Why this IA? Can you tell us why this IA in item number 7? Permission of delay.
Sir, for item number 6, I need a job.
তুমি নজন কোন আছে কোন যাবে ও আমার ওই তুই হদি না তুই না এখানে কনভেন্স হয়ে গেছে নিউ পত্র
Yes, what's your prayer in item 7?
Sir, my senior is suffering from cervical sciatic, so some
Who is your senior?
Mr. BK
What's your good name?
Irfana,
On behalf of Mr. B.K. Sen, leading counsel for the submitted that Mr. Chan is in this court. And he prayed for some time. It's counsel for preparing for the how much time? Yes, sir. Item number 6. You short time in the morning. Why you time? What's your good name? Mr. You are talking about Mr. Khan. Right. No, this is not this DB. The previous DB we had with my Lord Justice, Brother Justice Polita, not this. That we have not fixed that, but will come later. Okay. No representation on behalf of the petitioner on call. Come back to it. Just there's this matter. Mahmood, what is?
Well, I have limited prayer ballot in this. Lordship, I have sought a review of the order that is page 23, Lordship.
Okay, we'll come on the next day. Next day. Because it's a review and
Next day.
Nine hearing for the time. Don't make. Don't call. Mr. Goswami, we'll pass order to 126, 125 first. Mr. Siddhar,
I'm not paying.
we are fixing this matter on Tuesday next, right? Matter is pending for long because earlier on 2 occasions matter was part heard
That is on 14th.
on 14th. On the prayer of the council for the parties list on 14th of May. Burua. For, We'll propose to have this bench on 10:15 on 14. But as you know, this the Lordship's prerogative, Honorable Chief Justice to make it depends. So we'll see to that 14th. matter
Item 8 went out on the same day.
Yes, we'll have it on 14th. I'll say.
Yes, Poland, yeah, but they are probably late. I do not know where they have gone. They were waiting outside, my lord. I saw them outside.
Mr. Tamuli,
Yes, my lord. He was waiting, my lord. Downstairs.
you have his number, telephone number.
I do not have, my lord, but he told me that he's just going downstairs. So, my lord, I can send someone.
You are against the order of the tribunal.
Yes, my lord.
What is the illegal?
My lord, thing is this, my lord, lordship may kindly come to, my lord, there is a disciplinary proceeding, my lord. And my lord, pursuant to that disciplinary proceeding, he was removed from service, my lord. Now, my lord, my lord, charge memo, my lord, at page 58, my lord. There are 2 charges. My lord, at page 58, my lord.
Page
58, my lord. My lord, as per the attendance report submitted by SSC CRS DBWS by letter number so and so dated 21/3/2008, Sri Pradeep Kumar Nandi, working under SSC, is most irregular in his duty. He is a habit of remaining unauthorized absent from duty very frequently. This is serious misconduct in violation of rule 3.1, sub-rule 2 and 3 of Railway Service Conduct Rules 1966. My lord, number 1 charge, my lord. And my lord, lordship will find, my lord, the next page, my lord. My lord, this is his absence, my lord, the attendance register, my lord. Next one. My lord, this is, my lord, charge number 1, my lord. My lord, now this second charge, my lord. My lord, article 1, my lord, again. Sri Pradeep Kumar Nandi.
Page.
My lord, same page, my lord, 58. Second, my lord, second parameter. Sri Pradeep Kumar Nandi, while working as technician grade 3 under SSC CRS DBWS, is most irregular in his duty. He is in the habit of remaining unauthorized absence from duty very frequently and subsequently report for duty, covering the period of unauthorized absence from duty under PMC. Previously, Sri Nandi was taken up under DAR for several times for his habit of remaining unauthorized absent from duty and lenient view was taken to offer him a scope for improvement, but it has been seen that he has not improved at all. Rather, he has repeated the same offense of remaining unauthorized absence from duty. This persistent habit of remaining unauthorized absence from duty indicates the gross lack of devotion and negligence of duty, which is serious misconduct on the part of Sri Pradeep Kumar Nandi, the technician grade 3, showing herself as unbecoming of a railway servant. Now, my lord, these are two.
Now just tell us,
My lord.
when he is communicated or served upon the petition,
My lord, everything, my lord, is up, my lord. As per rule, my lord. Here is, my lord, no complaint regarding that, my lord.
right? Even if there is no complaint, when do you serve
What, my lord, my lord?
these two charges?
Yes, my lord, this is the charge memo, my lord.
When did you issue the so cause? When did he receive?
My lord, yes, my lord, receive, my lord.
When?
My lord, my lord, this is served on, my lord, issued on 4/4/2008, my lord. And my lord, lordship will find, my lord.
Hmm.
My lord, lordship may kindly come to page 102, my lord. This is the affidavit in opposition, my lord, rejoinder filed by the my lord, rejoinder by the applicant, my lord, before the Honorable Central Administrative Tribunal, my lord, at page 102, my lord. Page 102, my lord. My lord, thing is this, my lord, I'll go to those pages, my lord, where, my lord, the inquiry was conducted, my lord, and the, my lord, search officer, my lord, admitted his guilt, my lord. He has, my lord, he did not file any written statement, my lord. When, my lord, the punishment was, my lord, given, my lord, then also, my lord, he was given an opportunity to, my lord, submit his written statement, my lord. He did not, my lord, go for file any written statement, my lord. Then he filed a review, an appeal review, my lord. All those were, my lord, rejected, my lord. Hereafter, my lord, after 5 years, my lord, of rejection of the review application, my lord, he came before the Honorable Central Administrative Tribunal, my lord. Central Administrative Tribunal, my lord, passed the order that is my lord, the punishment given was disproportionate to the offense, my lord, committed by the respondent, my lord. And, my lord, it was directed to reinstate him, my lord, with back wages, my lord. And, my lord, that back wages part, my lord, we have reinstated him, my lord. Now he is, my lord, gone on retirement, my lord. And, my lord, this back wages part that has been stayed by the Honorable High Court, my lord. Now, my lord, lordship, I'll take your lordship to page 102, my lord, my lord.
Before that, we want to.
My lord, before that, my lord, this inquiry procedure, my lord. I'll take your lordship to the inquiry, my lord. Proceeding, my lord.
Now, during which period he was absent? What was the periods of absence?
My lord,
Because that periods definitely you have incorporated in the.
Yes, my lord. Yes, my lord. This is the, my lord, the page 59, my lord. My lord, this is a type copy. Possible page at page 61, my lord.
Page 59 is the period during which you remain absent.
Absent, my lord. And, my lord, original copy is, my lord, at page 61.
Okay. Now, this starts from 1st of January 2008.
My lord.
And it's up to 21st of March 2008. Now, first he remained absent with casual leave. Right?
Right. My lord.
Second, casual leave. Third, casual leave. Fourth, casual leave. Fifth, casual leave. Sixth, casual leave. So, after first, he was present on second. We don't know of the calendar, of course, we have to take out the calendar. Hold on. Sharma. Down. First January, he remained absent.
My lord,
2nd January was Wednesday, he was present. Then 3rd Thursday, CL, 4th CL, 5th CL, 6th Sunday, 7th CL, then 8-1 he worked, 9-1 he worked, then 10 he worked, 11 was CL. He is entitled for 1, 2, 3, 4, 5, 6, okay. Then 12 he remain absent. Then 13, 14, 13 is a Sunday, so it is 14. Then 15. 14, 15, দেখো না হলিডের কথাও কোৱা নাই যদি হলিডে 16, 17, 18, of course he was not there.
not there.
And 19
my lord.
Saturday,
21,
21 is Monday, okay.
22, my lord, first part, my lord.
22nd, second part,
Yes, my lord.
22nd,
You can do my lord, first part, my lord. Sorry, my lord, that is the typographical error, my lord. In the page 61, lords, you will find, my lord. The original copy,
23,
my lord. 61, my lord. First-
1/2 he has walked.
Yes, my lord.
23rd he walked. Then twenty-eighth January, first half or second half?
Right.
Second half he won.
Right.
Okay, 1/2. he was.
22nd, January, first part, my lord. First,
29 he was there. Then 31st,
30, full.
Take care, take care. Mr. Cal waiting for the single bench. Not possible. Right on 14th Tuesday. It's a new matter or old man? First time.
Second time.
Lordship granted bail to co-accused also.
Monday. Monday.
Lordship.
Mr. Goswami, out of 26 working days in the month of January, he took CL on 1, 2, 3, 4, 5, 6. That he is entitled for 6. So it has become 6 goes means 20. So 6 CL, so it becomes 20 days. Out of 20 days, 20 working days, you work for 11 full days and 2 half days. Okay. In the month of February, out of 25 working days, he worked for 20 days. And on 3 occasions, half days. In March, out of 18 working days, because this is up to 21st of March, he has found that he worked for 3 full days and 12 half days. This is what we have found meeting with the calendar. And
Now, coming to he's happy.
But we have stayed at 102 or 112, I think so. The finding is there.
Now, the second SARS, he is in a habit of remaining
Where
unauthorized.
from that? Where from you are saying? That habit, see, if it is past habit, you have not taken any action.
My lord, kindly, lordship, my lord, that's why my
You
lord.
can see, but did you take any action on
Yes, my
that?
lord, yes, my lord. Yes, my lord. My lord, may kindly come to page 102, my lord. My lord, 102, my lord. May I read, my lord? From the memorandum of charges, it is clear that the disciplinary authority has mainly relied upon a report dated 21/3/2008, which has dealt with the period of absence between 1/1/2008 to 21/3/2008. In this regard, it is stated that the case of the applicant was not a case of continuous absence from duty from period between 1/1/2008 to 21/3/2008, but he was absent from his duty for some spell. And in most of the cases, he was absent in half days under compelling circumstances. Regarding allegation of unauthorized absence of several earlier occasions, it is stated that the allegations were vague and there is no valid foundation for the same. The disciplinary authority has failed to mention any specific period on which the applicant remained absent from his duties in earlier occasions. Further, the respondent have not proceeded with any DAR against the applicant on earlier occasions. It is admitted that earlier on one occasion, memorandum of charge was served upon the applicant alleging unauthorized absence, but later on the same was dropped as the applicant was sick and has submitted sick certificate from Relay doctor. There was no other occasion when DAR was initiated against the applicant as alleged. So he has, at least for one occasion, I have annexed documents to show that the disciplinary proceeding was initiated, and lenient view was taken.
Before the tribunal.
Yes, my lord. Now, lordship may kindly come to page 62, my lord.
Yes.
My lord, this is the inquiry proceeding, my lord, the questions and answer. Question number 1, why did you not submit application for sanction prior to avail leave or after absence from duty in most of the cases? As I thought I had no leave due to my account, so I did not apply. Why did you remain absent from duty frequently? For my mother, psychiatric patient, in her old age, she is residing with me and I have to look after her. This is, his father was ill, a psychiatric patient. Now, lordship may kindly come to page 64.
Page
Page 64.
64.
Right. Question number 8, last question, madam. Do you accept the charges against you? I accept this. Now, I'll place 3 judgments, under whether under these circumstances, such a penalty can be given. Number 1, he has admitted, once there is a proceeding, I'll show, from one document, at least, page 109, place 108 and 109, my lord. This is the office note, my lord, which I have annexed, my lord, to this, my lord. 108, my lord, service particulars of PK Nandi, technician grade 3. My lord, EAR particulars, my lord. Dated 9/9/2006 was issued for not carry out his superior's instruction and willful delay on line duty to NBCO and Guwahati. Increment stop for 2 years, 11 months. My lord. This is number one, my lord. Second, my lord, 5/12/2006 was issued for unauthorized absence from duty. Increment stop for 30 months. Number three, show cause notice for imposition of break in service by data number so and so dated 16/5/2000 was issued for habitual unauthorized absence from duty. Break in service from 17/1/2004. This is the, my lord, 3 instances, my lord, I am showing, my lord. And, my lord, in spite of all this, my lord, he has not, my lord, motivated himself, my lord, and, my lord, he continued to remain absent, my lord, in duties, my lord. And, my lord, thing is this, my lord, when, my lord, these charges are, my lord, accepted, my lord, there is no question of proving those charges, my lord. If he has denied these charges, my lord, he never filed a written statement, my lord. Never ever, my lord. When, my lord, the punishment was given, my lord, then also, my lord, he was given, offered an opportunity to file, my lord, his written statement, my lord. He never submitted any written statement, my lord. That means, my lord, he accepted these charges. But, my lord, thing is that this, my lord, he thought that, my lord, a lenient view this time will also be taken, my lord, against him, and that is why, my lord, he has not filed anything, my lord. My lord, he has taken the, my lord, the my lord, NFLA for granted, my lord. And, my lord, second thing, my lord, I would like to show, my lord, when, my lord, he preferred, my lord, the my lord, when, my lord, lordship may kindly come to page 32, my lord.
Page
32, my lord. Page 32, this is the, my lord, order, my lord, which he has challenged, my lord, special from service, my lord. Fourth para, my lord, last 2 lines, it has also been noted that previously C. Nandi was given ample opportunity to rectify himself, but he had failed to do so at all. Repeated the same offense in view of fact above, taking all factors in account. I, the disciplinary authority, therefore order the penalty of removal from service on the said PK Nandi, Pradeep Kumar Nandi, technician grade 3, be imposed with immediate effect. Well, this is the original order, my lord, by the disciplinary authority. Lordship may come to the next phase, my lord. My lord, this is the my lord, he filed an appeal, my lord. 24/12/2009, my lord. This order, my lord.
yes.
My lord, hence the last para, my lord. Hence the punishment imposed by the disciplinary authority is kept stand good, which is removal from service. This is the, my lord, appellate authority order, my lord. Next one is the original copy, my lord. It's a, my lord, then, my lord, revision, my lord. This order was also passed on 24/3/2010. My lord, same, my lord, it was rejected, my lord. Now, lordship, the next
When
phase,
these
my lord.
orders were, it is 24th of March 2010 was served upon the petitioner.
Yes, my lord.
When it was.
No denial, my lord. He has never denied, my lord. He only, my lord. There is no dispute, my lord, that these letters were not, my lord. But because, my lord, he himself, my lord, preferred those appeal and revision, my lord. Now, my lord, lordship may kindly come to page 37, my lord. Annexure 5, This is my lord, start of the OA, my lord. The OA is 40410 of 2015, my lord. After 5 years, my lord. Now, my lord, the honorable tribunal has passed this order for back wages, my lord. That is the main grievance, my lord. He has already, my lord, gone on retirement, my lord.
When did he retire?
My lord, retired, my lord, I have the document, my lord. It is
When did he retire? When did he
in
retire?
railway service on 31/1/2020, my lord. My lord, lots, may kindly,
31?
1/2021. It is noted that it is to state that Sri Pradeep Kumar Nandi has retired from railway service. Lots of may kindly. My lord, originally in original. My lord, I'm sorry, my lord, I have only one.
Doesn't matter. Date is 31st of January 2021.
Retire face এইটুকু জানি দেখতে না জানি। এটা retire হলে মোটামুটি হবই তো, মানুষ তো retire করতে ইচ্ছুক নাই না।
Okay, we'll take it up on Tuesday.
Yes, Lord. Regarding this delay only, I'm just pointing out that this OA was prepared in the year 2015. So that delay was condoned, and there was an MA for that condonation of delay that was allowed by the order dated 18/12/2015 by the Honorable Tribunal, and that delay was condoned, and that order was never challenged.
Give us a copy of,
Only one copy I was having,
make a,
and that has already attained finality.
give you that copy of 30, the retiring date.
Bye.
And regarding my submission, I will make on it. And I have given one.
Photocopies will be made and give it to you back.
Lordship, I have already given a written argument also. That will be the gist of my argument.
Written argument, yes.
That is the gist of my argument. I will submit the judgments referred therein.
My lord, I'll submit 3 judgments, my lord. I'll
Do it on that day.
My-
13 for further hearing.
My-
13 for section 4.
Lordship, regarding item number 9 of previous bench, Lordship, I have returned back the LCR, Lordship, that may be noted.
Item number 9.
9, State of Assam versus Mohammad Mala Begum. Yeah. First TB, regarding first TB, Lordship, that was not noted, Lord.
Your Lordship.